Good morning, everybody. Happy Monday, and may the 4th be with you. My name is Dan Soul, coming to you live from a freshly upgraded bunker deep in the heart of the Sonoran Desert. Be your guide for the next 4 hours on our journey through Courtlandia. We will start with the 44th District Court Magistrate. This morning it is Magistrate Urich.
Hearing true?
Yes.
So you understood the court's instruction that you must select from one of three options to protect your rights, yes?
Yes.
Thank you, Ms. Colvin. The citation before the court was issued March the 17th, so St. Patrick's Day this year at about 2:20 in the morning. You were operating a 2014 Audi black in color on 13 Mile Road, Edgerton, Maine, in the city of Royal Oak. At that place and time, it was discovered your vehicle plate had expired on March 12th of 25. So this is a simple expired plates citation, non-moving, 0 points. You may admit responsibility. You can admit, explain, and display an updated registration, or you can deny responsibility, and the court will swear the parties and take your testimony. What do you wish the court to do for you?
Admit, explain, and show my proof.
Terrific. So you're confirming that on the date in question, you were operating a motor vehicle in the city of Royal Oak with an expired tag, correct?
Yes, Your Honor.
And could you hold that up to your device, please?
I hope you can see it. Do I need more light?
Well, right now, our handicap is the fact that you've got a stutter in your transmission. So I don't know if Officer Gertler can see that or not.
I cannot, however, lucky
A little
for
bit of a
everyone.
delay.
Okay, hang on, Ms. Colvin. Officer?
Lucky for everyone, I did my homework on this and it is up to date, current to 2027.
Terrific.
That being said, I would like to make a motion to dismiss the citation, please.
All right, that's a motion to dismiss, Ms. Colvin. So you are all set. Thank you for being prepared and good luck to you.
Thank you, Your Honor. Thank you, Officer.
The court calls case number 26RO01744 and 44A. These are People versus Dylan Matthew Weldon. That's you, sir?
Yes, sir.
Mr. Weldon, you were present a few minutes ago when the court explained the nature of an informal hearing. True?
Yes.
So you understood the court to instruct that you must select from one of three options to protect your own rights, correct?
Yes.
Thank you, Mr. Weldon. The citation before the court was issued on March 28th of this year at about 11:15 in the evening. You were operating a 2007 Chevrolet, white in color on Woodward Avenue, M1 Avenue, Coolidge Highway, City of Royal Oak. And at that place and time, you were cited for expired plates. The vehicle plate had expired on October 1st of last year. You were cited for disobey traffic control device in as much as you failed to fully stop for a stop sign. And there's a warning that's not before the court today. So those are the two matters before the court. You may admit responsibility. You can admit and explain, or you can deny responsibility. And the court will swear the parties and take your testimony. What do you wish the court to do for you?
I'll admit guilty with an explanation.
Very well. So you're confirming to the court that on the date in question, you were operating a motor vehicle in the city of Royal Oak with an expired tag, and you intentionally or unintentionally disobeyed a traffic control device, correct?
Yes.
Thank you. Court appreciates your honesty. First, Officer Gertler, do you have any information on that plate?
Yes, it is current and up to date. For the expired plate portion of this, I would like to dismiss that citation, please.
Okay. That plate is dismissed. Mr. Weldon, whoever has that birthday will keep having them for years to come. So you'll know what to do next October.
Yeah.
And respect to the signal or the device, what, the stop sign, what would you like to say?
So that, I guess that's where, a bunch of people park at to like hang out and stuff. And,
Okay.
so it's, my girlfriend was hungry and she had that time of the month for girls. And
Mhm.
she got mad at me because I said I didn't want to park because the parking there was all messed up. So
Okay.
I wasn't really paying attention.
Okay.
And I guess when I pulled out, I didn't see the sign where it said right turn only, and I went straight across. And
Okay.
then I was arguing with her. So I know that's not an excuse, but that's the reason why.
All right. We could basically sum that up as much as you were distracted by a circumstance. And the most important thing we should do whenever we find ourselves in that situation is get ourselves out of traffic till that matter resolves, however that is to happen. Okay, so the court can empathize with your circumstances, but needless to say, Officer Gertler.
Yes, Your Honor, I would like to make a motion to amend that to impeding traffic, please.
Very well. That's going to save you considerable grief, Mr. Weldon. Impeding traffic is a 0-point violation, will not appear on your master driving record. That's acceptable to you?
Yep.
Very well. Your original plea will absorb a plea to impeding traffic. The fine is $175 payable through the pay portal on the 44th District Court website, or you may walk a cash check or charge into this court at 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30. The court is marking that due within 14 days. That completes your hearing. Good luck to you.
Thank you.
Calling case number 26, RO 01560, People versus Olivia Lee Disch. That's you?
Yes, Disch.
Is Disch. Thank you. Ms. Disch, you were present earlier when the court explained the informal hearing process, correct?
Correct, yes.
So you understood the court to instruct that you must select from one of three options to protect your rights. True?
Yes, Your Honor.
Ms. Disch, the citation before the court was issued March 21 of this year at a little bit past midnight. You were operating 2011 Ford Fusion, gray in color on Woodward Avenue, M1 at or near Normandy. At that place and time, you were cited for speeding a minimum of 1 to a maximum of 5 miles over. However, the officer's apparent radar reading clocked at a 61 and a 45. Regardless, this was written for 1 to 5, and today's your day in court. You may, if you wish, admit responsibility. You can admit and explain, or you may deny responsibility. The court will swear the parties and conduct your trial. What do you wish the court to do for you?
I would like to pick the second option. I would like to admit guilt, I guess with explanation.
Very well. So you're confirming to the court that on the date in question, you were operating a motor vehicle in the city of Royal Oak and exceeded the posted speed by at least 1 mile.
Yes, Your Honor.
Thank you. What would you like to tell the court, Ms. Disch?
I don't know if this is exactly a reasoning for it, but the night of, I was just driving into downtown Royal Oak to pick up some friends. I was offered to drive everybody home after a night at the bar. I'm new to the area. I'm not from Royal Oak. I live in Pontiac. I just moved to the area. I was just kind of cruising. When I got pulled over, it didn't kind of register in my mind that I had been speeding. And then he told me, and I completely understood, like, yep, I wasn't paying attention. I had a lot on my mind. I got laid off from my job that same day. So I was kind of just overthinking things, not really paying attention to my speed. I don't know if there is an option to do something like a class online, I would be more than happy to take that. But I just wanted to take the opportunity to come and at least try.
Okay.
So I really appreciate it.
No worries, and the court appreciates what you're telling it. The main job of any Michigan driver is to be completely aware of the circumstances and mindful. So if you ever have an occasion where you're just having a little bit too much on your mind, it's good to get out of traffic for a minute, for your own safety and the safety of those around you. Officer Gertler.
Yes, Your Honor. I would actually like to make a motion to dismiss this citation in its entirety.
Very well. There's a motion to dismiss. The court can't imagine you have a problem with that, Ms. Disch.
No, I don't. Thank you.
Have you found new work yet?
I have not. It's been a little bit of a struggle, but I'm working on it, and I really appreciate this. Has kind of been on my mind a lot last week.
Well, push this one to the side,
Yeah,
and
thank you.
as I tell my sons, keep cranking out those resumes. You take care now. Good luck to you.
Thank you so much. Do I have to? Is there a court fee that I need to pay to
You
you?
need to do nothing. You're
Okay.
all set. Just
I
drive safely.
appreciate it.
Good luck.
Thank you
Good
so
luck.
much. Thanks.
Calling case number 26 RO 01233. This is People versus Marshall L. Bennett. Mr. Bennett, are you available?
Yes, I am.
Thank you very much. Mr. Bennett, you were present earlier when the court explained the informal hearing process, true?
Yes.
And so you understood the court to instruct that you must select from one of three options to protect your own rights, true?
You're right.
Thank you. Mr. Bennett, the citation before the court is a relatively simple one. Indicates that on March 4 this year, about 6:45, you were operating a 2026 Toyota gray in color on Crooks Road at or near Webster in the city of Royal Oak. At that place and time, you were cited for exceeding the posted speed by a minimum of 1 to maximum of 5 over. That is a posted 30-mile-an-hour zone there. Officer Gertler's detailed note on your citation indicates a radar reading of 51 and a 30, but he wrote it for 1 to 5 over 30. Regardless, today's your day in court, Mr. Bennett. You may admit responsibility, you can admit and explain, or you may deny responsibility, and the court will conduct your trial. What do you wish the court to do for you?
I can admit it and explain.
Very well. So you're confirming to the court that on the date in question, you were operating a motor vehicle in the city of Royal Oak and exceeded the posted speed limit by at least 1 mile over, correct?
Mm.
Thank you. Mr. Bennett, what would you like to tell this court?
I'm new to Michigan. So I'm just getting at that moment I was getting used to our environment and the area. I don't know exactly where I was coming from, but I know the area I was coming from, the speed limit was a little more, was higher. So by that time, I just hadn't noticed that the speed limit changed on me. So I'm honestly, I understand it was my fault. It was totally on me. Officer called me what it was. So no complaint. But I was just a little, the change up of the speed at that moment just caught me. So it was no big deal.
Thank you very much. The court appreciates your remarks. As a future safety tip, the less familiar we are with an area, the more carefully we should drive.
Yes, sir.
And Crooks Road is appropriately named it because it's got a lot of turns on it.
Yeah, I see now.
Yeah. The first time you run that, you're like, where is this taking me? So anyway, okay, I appreciate that, Mr. Bennett. Officer Gertler, anything you want to share?
Yes, Your Honor. I'd like to make a motion to amend it to an impeding traffic, please.
Very well. There's a motion to amend to impeding traffic, Mr. Bennett, that is a 0-point violation, will not appear permanently on a master driving record. That's acceptable to you? Yes?
Yes.
All right. So the court's going to assess the fine of $175 that is payable through the pay portal on the 44th District Court website, or you may walk a cash check or charge into this court at 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30. That's due within 14 days. Please drive safely. Take care.
All right, thank you.
Good morning once again, everybody, and may the 4th be with you. TCF Live on a Monday. My name is Dan. It is good to have you all here. If you are new to this channel and have not yet said good morning in the chat, please take a moment to do so. We're a friendly folk around here. Let's change it up. Let's go down to Lake County, Ohio. Judge Culotta is taking the bench. Let's see what's going on there.
We are present this morning in the matter of State of Ohio versus Devin M. Harper. This is case number 26 CR 249. Present open court this morning is the defendant with his attorney Jim Matthews. We were here for a pretrial previously on this case, and since then I've had extended discussions with the defendant through his counsel about a potential resolution of this case. It's my understanding that the defendant does wish to resolve the case today at the change of plea and accept the state's offer, whereby he would be pleading guilty to counts 2 and 4 of the indictment. Both of those are the same charge, but different instances: unlawful sexual conduct with a minor, felonies of the 4th degree in violation of Revised Code 2907.04A. This would be a Tier 2 sex offense. There's no agreement as to sentencing. Victim is not here. However, prior to making this offer, the state did reach out to the victim and victim's mother, and they also approved that offer before the state made it.
And you may have said, has there been any discussion or agreements on sentencing recommendations which are part of the plea?
No, Your Honor.
Okay. All right, Mr. Harper, were you able to hear what the prosecutor just had to say regarding what he believes your intentions are here today?
Yes, sir.
He indicated to the court he believes that your desire to withdraw your previous entered pleas of not guilty to counts 2 and 4 and plead guilty to those charges, and I'll go over those charges with you to make sure you understand what they are. The other 2 counts would get dismissed. We would defer continued sentencing to another day to get some evaluations completed. Come back on a future day for sentencing where there's no agreement between the parties regarding any recommendations. Each side is free to recommend to the court whatever sentence they believe is the fair thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, most importantly, what you want to do today?
Yes, sir.
Well, before I can accept your plea, I need to make sure you understand everything we're doing here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you had that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine those issues, I'm going to ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to talk with your lawyer to ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, sir.
All right. Let's get started then. How old are you, sir?
24.
Are you able to read and write the English language?
Yes.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No.
Are you a U.S. citizen?
Yes.
Now, before you came into court here this morning, have you any drugs or alcohol of any kind?
No, sir.
What about in the last 48 hours?
No, sir.
Not even prescription medication, nothing?
No.
Okay. Now, you should have received a copy of the indictment in this case. I know you did. You got it sometime around middle of March, beginning of March. That's the document that sets forth the charges you're accused of committing. Do you remember getting that?
Yes.
And at some point you had the chance to look that over?
Yes.
Now, in that indictment, you're charged with 4 counts. You're pleading guilty to 2 of those counts. I'm going to go over those 2 with you. If you have any questions, make sure you ask. Now, the 2 counts are the same charge. It just occurred on 2 separate occasions. And what's alleged here in each of these counts is honor between June 29th, 2024 and August 31st of 2024 in the city of Mercer, Lake County, Ohio. That you, being 18 years of age or older, did engage in sexual conduct with AJ, who is not your spouse, and that you knew that AJ was 13 years of age or older, but less than 16, specifically 14 and or 15 years of age, or you were reckless in that regard in knowing that. That conduct constitutes the offense of unlawful sexual conduct with a minor, and it's a felony of the 4th degree. Do you understand what you're charged with and pleading guilty to in regards to counts 2 and 4?
Yes.
Any questions about those charges, the allegations?
No.
Now, there's 2 other counts of this indictment, 2 charges of sexual battery, which are more serious, but those are being dismissed pursuant to the agreement. Is that your understanding?
Yes.
Any questions about those 2 charges?
No.
Well, then, before I can accept your plea to counts 2 and 4, I need to make sure you understand all the rights you're giving up by pleading guilty, and you first of all have a right to have a trial in this case. Now, a trial could be to me as a judge, or I listen to the evidence and I make the decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. And a jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. Those 12 jurors would consider and weigh all that evidence, and then those 12 jurors would make that ultimate decision. And that ultimate decision reached by those jurors would have to be unanimous. Unanimous means all 12 of them would have to agree together, one way or the other, as each specific charge, whether you're guilty or not guilty. Do you understand that?
Yes, sir.
Do you understand by pleading guilty, you're giving up your right to have a trial?
Yes.
Now, if we did have a trial in this case, the prosecutor here would represent the state of Ohio, and he would have what we call the burden of proof. With him having the burden of proof, what that actually means is that it is his job, or he bears the responsibility or the obligation, bears the burden of proving you guilty before you could ever be found guilty. You're presumed innocent of all these charges. And that presumption of innocence will stick with you and remain with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes.
Now, we speak of this burden of proof since this is a criminal case. That burden is what we refer to as proof beyond a reasonable doubt. It's the highest burden we have in our justice system. What it actually means, it's the amount of the evidence and the quality of that evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of those charges beyond any reasonable doubt before you could ever be found guilty of those charges at a trial. Do you understand that?
Yes.
Do you understand by pleading guilty, you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes.
Now, in order to do that, or at least try to do that, if we had a trial, the prosecutor would bring witnesses into the courtroom to testify for the state, and they'd answer questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same persons questions, and that's called cross-examination. So he can ask them anything he wanted to, within certain rules. Do you understand that?
Yes.
Do you understand by pleading guilty, you're giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes.
Now, you'd also have the right at a trial. You can call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that. But you have a right to do that if you wanted. Do you understand that?
Yes.
And you further can request the court issue an order. That order is called a subpoena. What a subpoena would do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they were not willing to come in voluntarily on their own. Do you understand that?
Yes.
Do you realize you're giving up that right?
Yes.
Now, you also have a right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes.
And since that's your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But most importantly, the prosecutor here is not allowed to call you as a witness, make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes.
Further understand that if we did go to trial and you were found guilty of any of these charges, you would have the right to appeal or challenge that guilty finding to another court, a higher court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yes.
All right, well, do you have any questions at all about any of these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, sir.
You understand them all?
Yes, sir.
Do you still want to plead guilty?
Yes, sir.
Do you understand a guilty plea is a complete admission of guilt? So you're going to be admitting to what the prosecutor is alleging regarding these two counts. We're not going to argue later that you didn't do this or it's someone else's fault or anything like that. Do you understand that?
Yes, sir.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court, and then you will subsequently, on another day, be sentenced by the court. Do you understand that?
Yes, sir.
Now, as far as sentencing goes, you're pleading guilty to 2 felonies of the 4th degree. Both of these are punishable by a possible term in prison of a minimum of 6 months, a maximum of 18 months, or any whole number in that range of 6 to 18. Do you understand that?
Yes, sir.
Now, since there's 2 separate charges here that occurred on separate times, 2 separate incidents, if I impose a prison term, I would impose a prison term on each separate count. And as the judge, I have the discretion to run those prison terms either concurrent or consecutive to each other. Concurrent means together. You serve them at the same time. Whereas consecutive means one after the other. You serve the prison term on count 2, complete that, whatever it was, and then serve the prison term on the next count. You understand the difference there?
Yes.
So in this particular case, if I impose the maximum sentence on each count and ran them consecutive to each other, you're looking at a maximum possible prison term, in this case, of 3 years in prison. You understand that?
Yes.
Now, you currently have probation or parole to any other courts or agencies?
I'm sorry?
Are you on probation or parole, any type of supervision to any other courts or agencies?
No.
Do you have any other charges pending against you in any other court?
I do have a one charge pending for me right now, but it's supposed to close on June 3rd.
What is that?
Domestic violence case,
What court is that in?
Minor Municipal Court.
Is it a misdemeanor or a felony?
It's a misdemeanor. They put it down to a misdemeanor.
Okay.
I believe an M5.
M5?
Yes.
Or M4? There's no M5.
Oh, M4.
The M4 is the lowest there could be.
Oh, yeah, it was the lowest one.
I guess it could be a minor misdemeanor, but they don't have those for domestic violence. The reason I ask that question is if you have another case, another felony case, and you get sent to prison before you come back here for sentencing, I could run a prison term concurrent or consecutive to that. But it doesn't appear that that's the case here. It's a misdemeanor case. If I were to impose a prison sentence, whatever time if you're serving any time on a misdemeanor, it would automatically be concurrent with the felony charge. You understand that?
Yes, sir.
Now, if a prison sentence is imposed in this case, upon your release from prison, you would be placed on post-release control in this case for 5 years. It's mandatory. Post-release control is sometimes referred to as parole. It's a period of supervision you would be on after you completed a prison sentence. In this case, being a felony sex offense, post-release control is mandatory for 5 years. Do you understand that?
Yes, sir.
And if you're on post-release control at any point, never violate any of the conditions of your supervision, the parole authority can send you back to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term is imposed by the court. Do you understand that?
Yes, sir.
All right. Now, aside from the possible prison sentence, there are other sanctions that can be ordered. You could be fined in this case. Each charge carries with it a possible fine of up to $5,000. So together there's a possible fine of $10,000. You can also be ordered to pay court costs. You can also be ordered to reimburse the county for any costs of confinement, community supervision, or treatment, if any that were applicable in this case. Do you understand that?
Yes.
This case, being a sexually oriented offense, also carries with it mandatory registration requirements. You'll be classified at the time of sentencing as a Tier 2 offender, which will require you to register your home residence, address, where you work, and or go to school with the sheriff in that county every 180 days for 25 years. Do you understand that?
Yes.
Now, a few moments ago, I explained the possible prison sentence. I used the word possible. Prison is not mandatory with these charges. You are eligible for probation, or what we call community control sanctions. Do you understand that?
Yes.
Do you understand that just because you're eligible doesn't mean you'll automatically get probation? It means I'll consider that, if that's what you're requesting. I'm going to look at all the information presented. And then I'll make the decision I think is the right thing to do. Do you understand that?
Yes.
Now, if you are put on probation, it could be for up to 5 years of supervision. And as the judge, I do have the discretion to order a wide variety of rules and conditions for you to follow. One of the conditions of your probation can be in order that you serve a term in the Lake County Jail of up to 6 months. So even if you get probation, that doesn't automatically mean there's no incarceration. It could be local incarceration for up to 6 months. Do you understand that?
Yes.
And if you are on probation and never violate any of the conditions of your supervision, we would have a hearing here in court to see if you're what's called a probation violator. If it was determined that you were, I could extend your probation up to 5 years if it wasn't initially 5 years. I could order more restrictive sanctions against you, or I could terminate your probation and send you to prison at that point. If I sent you to prison at that point, again, it could be for that range I told you about before, 6 to 18 months on each count, consecutive for up to 3 years. And that could also be consecutive to any other sentence you may be serving at that time for something else, or that you're being sentenced to if there's a new charge. You understand that?
Yes.
Lastly, when we do come back here for the sentencing hearing, you're going to have the right on that day to say anything you want. Anything you want me to know or consider. Your lawyer could speak on your behalf. He can recommend the sentence to the court. Prosecutor can also recommend the sentence to the court. Do you understand that?
Yes, sir.
Do you understand that whatever anyone says at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to follow that if I don't think that's the right thing to do. Do you understand that?
Yes.
All right. Well, do you have any questions for me about the potential penalties you face by pleading guilty?
No, sir.
You understand all the possible consequences and what can happen at sentencing?
Yes.
Do you still want to plead guilty?
Yes.
Have you had enough time to talk about this case with your lawyer and have him go over the reports with you, discuss the issues, answer whatever questions you may have?
Yeah, we had appointments.
Okay.
before.
Are you satisfied with his advice and counsel?
Yes.
Has he, or has anyone for that matter, made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty here today?
No.
Have you been threatened or coerced in any way to plead guilty?
No.
Are you entering your guilty plea freely and voluntarily today?
Yes.
All right then, Mr. Harper, any questions for me at this point regarding anything we've just talked about? The rights you're giving up, penalties you face, what you're pleading guilty to, any questions at all?
No, sir.
Do you need any more time to speak to your lawyer before we go forward with your actual guilty plea?
No.
All right, then what's going to happen at this point, the prosecutor here is going to explain for me what he believes the evidence would establish at a trial if we did have a trial. I want you to listen to him because then I got some follow-up questions for you about that, all right?
Yes.
Mr. Downing?
Thank you, Your Honor. Had this matter proceed to trial, the evidence would have shown that between June 29th of 2024 and August 31st of 2024 in the city of Menor, the defendant had sexual intercourse with AJ on 2 separate occasions at his residence. AJ was known to the defendant because she was friends with the defendant's younger sister. AJ had consumed alcohol on both occasions. She was 14 or 15 years old at the time. Her date of birth is 7/11 of 2009. The defendant was 23 years old at the time. His date of birth is June 15th of 2001, and he did know AJ's age. This conduct was not discovered until February 2025 when AJ's mother found text messages between the defendant and AJ referencing the prior instances of sexual conduct, which then began the police investigation.
Mr. Harper, were you able to hear what the prosecutor had to say regarding what he believes the evidence in this case would show if we did have a trial?
Yes.
What, if anything, do you have to say about those facts as he presented them? Are those facts true? Did you do what he said?
Yes.
Very well, then, regarding counts 2 and 4, both charging with unlawful sexual conduct with a minor, both felonies of the 4th degree, what is your plea to each of those 2 counts?
Guilty.
All right, I have in front of me a 4-page document called a written plea of guilty and judgment entry, which sets forth and explains everything I've just gone over with you. Before I can accept your plea, I need to make sure you understand this document, that you sign it here in open court. Now, my understanding is that before I walked out here today, you had a chance to go over this document with your lawyer. Is that correct?
Yes.
Mr. Matthews, is that accurate? Did you review this with Mr. Harper, read it to him, answer his questions?
Yes, Your Honor.
Did he indicate an understanding of it to you when you did that?
He did.
Is that correct, Mr. Harper?
Yes.
So you understand what this document says?
Yes.
Any questions for me about it?
No.
Now, it also appears that you signed the document. Did you in fact sign it?
Yes.
And you witnessed that, Mr. Matthews?
Yes, Your Honor.
You too, Mr. Downing?
Yes, Your Honor, and I signed it as well.
Very well, then, at this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect, the defendant was here in open court with his lawyer, advised of all his constitutional rights, made a knowing, intelligent, and voluntary waiver of all those rights. Court also finds the defendant understands the nature of the charges, the effect of the guilty plea, as well as the maximum penalties that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea, find the defendant guilty of counts 2 and 4, unlawful sexual conduct with a minor, each felony is of the 4th degree, and each in violation of revised code section 2907.04A. Counts 1 and 3 will get dismissed at sentencing, but I'm going to defer continue sentencing to another day. I'm going to order a pre-sentence report and investigation, victim impact statement. Any other evaluations you're requesting, Mr. Matthews?
No, Your Honor.
I'll continue bond at own recognizance with an order that you have no contact with the victim or their family or residence. So what all this means at this point, Mr. Harper, as far as bond goes, I'm not changing your bond at all. I'm continuing at what it was. Own recognizance. First off, that means you have to appear at all future court dates, and the only other future court date we have is your sentencing, and that is going to be June 22nd at 2 o'clock. So you need to make sure you're here for that. If you fail to appear for your sentencing hearing, that's a separate felony that you can be prosecuted for, separate and apart from what you just pled guilty to. You can get up to 18 months in prison on that, in addition to whatever I would sentence you to. So it's obviously important you show up at your sentencing. You understand that?
Yes, sir.
Also, one of the conditions of your bond is that you don't use any drugs. You'll have to submit urine screens if they're requested. They have to be negative. A positive screen will result in your bond being revoked and a warrant being issued for your arrest. You understand that?
Yes, sir.
Now, the purpose of these report, or the report I've ordered, the pre-sentence report, is so I can learn more about you before sentencing. The way the probation department gets the information they need to prepare this report is they're going to conduct an interview with you. It's very important that when you meet with them that you're open and honest with them, because they're going to check and verify everything you tell them. And if they learn you're misleading them in some way, whether it's flat out lying or even just minimizing something or exaggerating something, they're going to let me know that, and I would consider that sentencing. You understand that?
Yes, sir.
Also, this pre-sentence report has to be completed if I'm in order for me to be able to consider probation as an option. Without a pre-sentence report, the law doesn't allow me to consider probation, and I'd have to send you to prison. Now, in order for a pre-sentence report to be completed, that interview with you has to take place. So it's important that you show up on time, when scheduled, at the probation department for that interview. Because if they can't interview you, then they can't do a report. And as I said, without a report, I can't consider probation. You understand that?
Yes, sir.
All right, so what you're going to do now, you're going to leave here. You're going to go right over to the probation department. Your lawyer will show you where that is. You're going to fill out some initial paperwork and get your date to come back for your interview. So make sure you go over there when you leave here now. All right?
Okay.
All right. Mr. Downing, anything else at this time?
No, Your Honor, thank you.
Mr. Matthews?
No, Your Honor. Thank you.
Thank you.
All right.
Morning, everybody. TCF Live on a Monday. Good to have you all here. So this weekend we made some upgrades here in the studio. If you were a channel member, if you go to the community tab, I posted some behind the scenes photos for channel members. But one of the things you'll notice right now is the camera's a little tighter on me than it used to be. So you get a better look at my ugly face. Sorry about that. However, as a bonus, you get much better close-ups of Ellie, like right now. On cue, by the way. Thank you, sweetheart. So, long story short, everything is in an effort to bring better content, more improved content, all that kind of stuff. We always try to get just a little bit better here, so that's what we're working on. With all that having been said, let's move along. Oh, no, before we move along, I forgot. When we left each other on Friday, we talked about how Mrs. TCF may have jury duty today, so we weren't sure if we were going to be able to have a morning show. She does not have jury duty this morning, thus we're here. However, it is possible she'll have to go this afternoon, and we have to call at 10:15 my time to figure that out. So we're going to run a little bit past the 4-hour mark today, and I'm going to call while I'm still on stream so I can let you guys know whether or not we're going to be able to do In the Blind tonight, because if she gets called in, we're not going to be able to do In the Blind. So we will see how that goes. All right, now let's go Huron County, Michigan. Judge Prill.
State of Michigan versus Coyote Marks, file number 267451F. Time and date set for arraignment. The defendant, Mr. Marks, appears from the county jail. He's currently in the Zoom application, represented by attorney Michelle Artsiv, who also appears via Zoom. The people are represented by prosecuting attorney Timothy J. Rutkowski. Ms. Siff, have you received a copy of the information that's been filed in this case? Have you and your client had the opportunity to review it, and you waive the reading as well?
Yes to all the above, Your Honor.
All right. Is there a plea agreement at this time?
There has been an offer that's been extended. However, at this time, after speaking to my client, he at this time wishes to reject the offer.
Very well. Mr. Rutkowski, do you wish to place the offer on the record at this point, or you don't have to? I just know you've done so in the past a few times.
Yes, Your Honor, we can do that, but that's free. Your Honor, the offer that was emailed is that Mr. Marks could plead to the charge, no contest, assault, strangulation, habitual offender, third offense. People agreed to dismiss the domestic violence count. Defendant agrees to pay full restitution, and the parties have would agree to stipulate to a guideline range of 10 to 34.
All right. Ms. Siff, is that your understanding of the plea offer?
Yes, it is, Your Honor.
And your client rejects that at this point, correct?
That is correct at this time.
All right, thank you. As to both counts in the information alleging on or about March 4, 2026, Caseville Township, Huron County, Michigan, count 1, assault by strangulation, and domestic violence, count 2. How does your client plead?
He stands mute, Your Honor.
Not guilty pleas will be entered on behalf of the defendant. You're going to have his pretrial conference right now. Is this to be a jury trial or bench trial?
Your Honor, this would be a jury trial.
How many days of trial do you anticipate coming?
Day and a half, Your Honor.
This it?
I would agree.
All right. You have a suggestion regarding a date, counsel?
I don't know offhand, Your Honor. I know he's incarcerated, so
Right.
take priority.
Ms. Siff, do you have an idea? If not, just take a look. And he is incarcerated, obviously.
Right. So I mean, it depends what the court has, I guess, at this time.
How about July 6th?
Oh, for the final pretrial?
Trial.
July 6th. Okay. Yeah, that would be fine.
Okay. July 6th, 2026 at 9 a.m. trial date, final pretrial date. Ms. Hatch.
June 15th.
Ms. Siff, are you available June 15th?
I'm not in the morning, Your Honor. I'm not available that day.
June 22nd.
How about June 22nd?
Yes, I am.
All right, final pretrial, June 22nd. Now that date will serve a multitude of things. One, it is the plea cutoff date. If any plea is to be perfected, it is to be perfected no later than the close of business that day. Serves as a motion cutoff date too. Any motions need to be filed and heard on that date. Finally, it also serves as a cutoff date for filing defense notices such as alibi or insanity. That's the reason for the June 25th, I'm sorry, June 25th date. June 25th? 22nd. It was 22nd, I'm sorry, June 22, 10 a.m. Mr. Rutkowski, have all the witnesses been endorsed?
Best I can tell, but I just want to double check. The court said July 6th, right? It's a Monday. So no motion day that day.
No motion day.
As far as I know, yes, Your Honor, we've listed all the witnesses.
All right, thank you. Ms. Siff?
I would ask for the court to give me a couple weeks to do that.
All right, 14 days for the defense to present witness list. Preliminary exam was waived. Either party intends to utilize electronic equipment to set it up the morning before trial, the day before trial, or the morning of, before the respective panel arrives. Proposed jury instructions shall be filed with the clerk of the court no later than 14 days from trial, as well as final instructions in Word format 2.1 forward to the court's email address. Mr. Rutkowski, you anticipate a large number of exhibits?
No, I do not.
Ms. Siff?
No, Your Honor.
All right, those can be marked the morning of trial. Anything else other than bond, Mr. Rutkowski?
Yes, Your Honor. Given that there is no plea, the people would be filing the habitual offender notice for fourth offense.
So noted. All right. Does have anything else to address other than bond?
No, Your Honor, just I wanted to address bond quickly.
Bond was set at $10,000, 10% has clearly not been posted. Ms. Sid, your position on bond?
I would ask for the court to consider a lower bond, possibly in the amount of 5,000, 10%. Mr. Marks does not have the funds to post any bond at this time, or at least the current amount. He may be able to post the 5,000, 10%. So I would ask for the court to strongly consider that. And we would not object to a GPS tether if that would make the court feel comfortable as well.
Thank you. Mr. Rakowski, your position on bond?
Your Honor, we believe that the bond was appropriately set in the district court. This is the case that the allegations are strangulation of the victim. So that's a pretty significant type of an offense. In looking at the defendant's criminal history, he has multiple felony convictions for breaking and entering, for stealing, retaining a financial transaction device, operating while intoxicated, domestic violence, another operating while intoxicated third offense, resisting, obstructing a police officer. So we believe that under those circumstances, the bond was appropriately set. We'd ask to continue it.
Thank you. Does Sid, any other comment?
Just for the court to consider the dates of those offenses. In regards to the domestic violence, I believe that was about 10 years ago. So I'd ask for the court to consider that as well. Mr. Marks, he resided in the county for a majority of his life, I believe. And I don't believe that if he does pose to be a flight risk, again, we don't have any objection to a GPS tether or any other conditions the court may feel that is appropriate to ensure that he does show up for his next court date.
Very well, thank you. Court has to consider MCR 6.106 regarding bond conditions. Clearly, this is not a life offense. However, with potential habitual for it could be a life offense, number one.
And he just turned off his feed for no apparent reason, but okie dokie, whatever. Good morning once again, everybody. TCF Live. I was just going through my my feed of news and everything else, and those of you who participate in the private chat, the behind the scenes one, you'll know that we have a whoop. Are we back?
I don't see any issue pertaining necessarily to flight risk. The danger to the public is significant. There are prior felony convictions making this habitual offender for. Some of them are assaultive in nature, and as a result, there's a safety interest to the public in general. And as a result of that, court finds the bond is appropriately set. Bond will continue over the objection of the defense. That'll be all.
As I was saying before, the judge rudely interrupted me by deciding to turn his feed back on. Those of you who participate in the private chat behind the scenes know that we have a wildfire just a few miles away from the bunker right now. And I noticed in the chat, it has, and this started like Saturday, it has grown to over 1,000 acres now. So really growing. We're about 3.5 miles away from it, but not really in a danger zone, but something to keep an eye on for us for sure. Anywho, let's go to Florida. Wade Mercer.
Good morning, Mr. Smith. You're here because you've been accused of violating the terms of your county probation. Among other things, it's really financial plus a new charge in Gadsden County. Mr. Smith, Mr. McDaniels made us aware of some additional factors just a couple of minutes ago once he spoke with you. Mr. McDaniel, you've got no bond right now, but Mr. McDaniel, you just want to work on this a couple of days and see if y'all can work something out.
We just probably want to go ahead and take care of it, Your Honor. I mean, I just talked to him real quick, like, and we just want to get, I mean, it is what it is. He was driving, we're not contesting it. And we just want the court to be aware that he has been trying to do it. He's did his anger management and, you know, and he did turn himself in and he called Tim, I think Mr. Ham immediately when it happened and let Mr. Ham know about it. So I think hopefully probation's there to verify that. We're just going to go ahead and take care of it.
Okay. So Mr. Smith, let me explain a couple of things to you. You have the right to a violation of probation hearing. If you exercise that right, then we'll schedule a hearing. You'll have an attorney appointed to represent you. You'll get to call and cross-examine witnesses at that hearing. However, if you admit that you violated your probation, you're waiving that right to the hearing. You will not get to call and cross-examine witnesses. If you enter admission, I'll listen to Mr. McDaniel, I'll listen to you, I'll listen to the state and the probation office, and I'll sentence you to what I think is appropriate. The maximum penalty that you could be sentenced to is 1 year in jail. That's the maximum. I'm not saying I would sentence you to that. I think the offer this morning was 6 months, but Mr. McDaniel thinks there may be some things that might can convince me to lower that, and there may or may not be. But I need you to understand you're waiving those rights if you enter this admission in violation of probation. Is that what you want to do?
Yes, sir.
All right, so I'm going to accept your admission that you violated the terms of your probation. I'm going to find that admission is freely and voluntarily entered with the advice of counsel. There are 3 allegations in the violation of probation affidavit. 2 are financial, court costs and fines, and not paying cost of supervision. The 3rd one is the new charge in Chattahoochee back on March 26th. I looked at your driving record. You have multiple suspensions on your driving record.
Yes, sir.
And then your criminal history overall is not good. And those were factors I considered when I made the tentative offer this morning. But I'm glad to listen to anything you or Mr. McDaniel or Mr. Mitchell want to tell me. Mr. McDaniel, who do you want me to hear from first?
I can go ahead and Your Honor, that, obviously, we're not contesting that he was driving. He was driving, he violated the probation, and with the new charge. And we're just letting the court be aware that, he has, I know he has a long criminal history, but he is trying to do things better. He's trying to figure out ways to get his license and trying to figure out money ways. And he also has, went above and, I didn't think he would do this. He went and took anger management classes and, he hasn't had the money to pay fines off, but he has been attempting to do things correctly the best he can. So we're just going to want the court to be aware of that. And when he found about the warrant, he's going to turn himself in.
Yes, sir.
Thank you for telling me all of that. Are you working or were you working before you got arrested, Mr. Smith?
Yeah, well, my thing is, since I've lost my license, I was working at Capital Asphalt when I got out of the feds last time. I've been almost 5 years out of prison this time. I've never been out more than a year ever. And I got hit by a minivan on Highway 20 walking at 40 miles an hour and completely taken out of the game. Well, 2 weeks later, the Percocet and the drinking, and then I caught a DUI. And I've just not been able to get back on my feet since then, and being stuck in Cottondale. There's no work and there's just no way for me to get around. So my mom gave me this 2019 Ford Explorer Limited. And you know me, Mr. Control Freak, just as soon as I get a way to do it myself, I give up surrendering everything to God now. And I grab the steering wheel and go, and it was a mistake. But I called Mr. Ham the following Monday and let him know exactly what was going on. They let me go. They heard my story and understood. And I continued to do my anger management until the completion of the anger management classes, even though I knew I was going to violate with the DWLSR. But I just want you to know that I appreciate everything from the court. I'm sorry about wasting any of your time or resources. Thank you, sir.
Thank you very much. I'm looking at the DOC website. You went to prison twice, but you got out in 2020, correct? 6 years ago?
Yes, sir. Yes,
Almost
sir.
6 years ago?
Okay. I went back on a small federal violation technical after that, but it was nothing, just to clean up my fed case.
You went to Federal Bureau of Prisons then?
Yeah, in between, the big chart, in between those two convictions on the state, I did 10 years in the feds. Yeah.
All right. Let me see if the state or the probation office has anything else. Mr. Mitchell, anything?
I don't have anything at this time, Your Honor.
Mr. Goodson.
Oh, so he did check in according to Mr. Ham's notes, and he did call. He's only paid $10 towards his court costs since he got put on probation. So it was originally $722. He has a fine arrears of $712.
Okay. What about how many days credit does he have, Mr. McDaniel?
10 days.
Mr. Smith, what I'm going to do is I was not aware until Mr. McDaniel made us aware by text of you turning yourself in. I was also not aware of you doing some of the anger management or all of the anger management classes. In light of that, what I'm going to do is I'm going to send you to 4 months in the Jackson County Jail. Give you credit for the 10 days you've served, order court costs and fines that you have remaining of $712. Mr. Smith, there's no probation to follow. You finish this 4 month sentence. Actually, it's less than 4 months because of your credit. Also, you very well may get in the trustee program. I've encouraged you to do that, Mr. Smith. Check that program out at the jail and get you some extra gang time. Put this all behind you. Move on with your life. Mr. Smith, I do wish you the best. Do you have any questions?
No, sir. Thank you, Judge Mercer.
Have a good day, sir. I wish you the best.
How much credit does he have?
10 days.
10 days. Okay.
Yes. We have State versus Michael Eubanks. Mr. Eubanks, good morning. You're here for first appearance, charged with possession of methamphetamine and resisting an officer without violence. Mr. Eubanks, we have, I know they're twins. Was it this Eubanks we had last week?
It was Nicholas that we had.
It was
last week.
Nicholas we had last week. Okay. So, Mr. Eubanks, there is probable cause for these two charges. And Mr. Eubanks, let me check. Does this Mr. Eubanks have any charges pending?
He's on a PTI in case number 25413CF.
What charge?
I think it was petty theft and dealing in stolen property.
Anything else from the state?
Correction, it was grand theft and petty theft. Other than that, no, Your Honor. He was just put on last week, 421.
And Mr. McDaniel, anything from, on behalf of Mr. Eubanks?
No, Your Honor, that's all accurate what the state said.
Was there a condition of random urinalysis on the PTI?
Let me see.
I'm trying to find it too.
See, the PTI accepted this letter, but I'm not.
Well, I showed this, Mr. Eubanks, being in court last month.
Yeah, 421.
And been sentenced to 48 days time served. So he just got out of jail. Mr. Eubanks, I'm going to set your bond at $7,500 on the methamphetamine and $3,500 on the resisting. Your total bond's $11,000. Mr. Eubanks, your bond has a condition of random urinalysis. The state attorney's office typically doesn't ask that bonds be considered open if once you sign that PTI paperwork. So they can kick you out of the PTI program. They very well may, but they're not going to ask to revoke your bond per their policy. So I'm not going to revoke that bond, even though technically you probably have a pending charge. That's the state attorney's office option. So you've got a bond of $11,000 cash or surety. The jail's going to give you a notice for your court date, which will be
June 2nd, I think. And you're
June 2nd at 8:30, Mr. Mitchell.
Your Honor, his deferred prosecution agreement did also have a condition of random UAs. So we would request that he be drug tested.
Thank you. So Officer Whitakerson, if we can get a urinalysis after first appearance, since that is a condition of his PTI. And Mr. Eubanks, do you have any questions?
No, sir.
Any questions?
No, sir.
Have a good day, sir. And we have Ray Wilson. I see Mr. Wilson signing something, so I will wait till he gets through. Mr. Wilson, I saw you this weekend on that Fugitive warrant from Thomas County, and I told you I wanted you to talk to an attorney before you made any decision. Looks like you just signed a waiver of extradition. Do you have any questions about that waiver of extradition process?
No, sir.
Mr. Wilson, they have 30 days to pick you up. We review the cases in 15 days just to try to keep a track on them. If you're still here in 15 days, I'll see you and I'll ask the jail where we stand on transport. There's a good chance you won't be here then. There's a good chance you'll already be back dealing with these charges in Thomas County, Georgia, because I believe isn't that Thomasville?
Yes, sir, it is.
It's right over the state line. So there's a good chance I won't see you, but if you're here in 15 days, we'll see what's going on with the transport. Any questions?
No, sir.
All right, sir. I wish you the best. I believe that's it for first appearances. Everybody else from the weekend was felonies, it appears. Mr. McDaniel, anything else from the public defender's office?
No, Your Honor.
Thank you, sir. Mr. Mitchell, anything from the state?
Nothing from the state, Your Honor.
Officer Whitakerson, anything else from the jail?
No, sir.
Williams?
All right, sounds like he's done. Real quick, just in the chat now, we're talking about fire, which is fine. But Graham and TCF just put, as of the latest update, the fire is still 0% contained. Mrs. TCF and I did a little bit of digging and learning and researching this weekend. And that statistic, when you hear percent contained, isn't necessarily what you think it means. Long story short, they won't say that a fire is a certain percentage contained until the person in charge of the team is confident that that line will hold. So it's not that it's like completely out of control. It's that they're not at a point where they can say, yes, what we've done will absolutely contain it to this percentage. So just something to bear in mind, because they throw that around a lot on the news, whether it's this fire or any other. And it sounds more sensational, I think, than it really is. So I just thought I would share that. Anywho, Texas, let's say good morning to Judge West, the Monday Fashion Show.
Good morning, ma'am. Did you get a lawyer hired?
No, ma'am, but I actually talked to 3 of them, and I have a consultation today at 1:30. Mr. Joseph, I talked to Miss Brittany and Miss Reagan. Oh,
Uh-huh.
yes,
And who is it with today?
Mr. Joseph, his last name started with L. I'm not pronouncing it.
Okay. So do you think you're gonna be able to get one of them hired if I give you one more reset?
Yes, no.
All right, so I'm gonna reset it one more time. You need to try to get one of them hired. If for some reason it's not gonna work out with them, make sure you visit with at least 3 others. Bring me those names and then we'll discuss your options.
Yes, ma'am.
Thank you for doing that. Step in front of the clerk. Lovestor, Hayson. Good morning, you're Lovestor Hayson. And Mr. Hayson, did you get a lawyer hired? Who did you talk to? Just tell me.
What's his name? James or Macon? Who that's name? Like this one, the Gertz, the Kelly Gertz level.
And so where are you gonna be able to get somebody hired?
Still looking through them.
Are you working?
Yes, ma'am. Assist.
I'm sorry,
Assist.
assistant?
I can let myself in, like do plan work.
Okay. All right, so you're gonna be able to get one of those lawyers hired? Well, the point wasn't to just talk to lawyers. The point is to hire somebody.
Other quotes I had to.
Right. So that's my question is, you think you're gonna hire one of those that you already talked to?
Yes, ma'am.
Okay, so I'm gonna reset you one more time to get someone hired. Make sure you either get one of them or someone else hired. If for some reason you can't, as you can tell from talking to them, they all charge different amounts and payment plans. So find somebody and get them hired before that next court date, okay? Step in front of the clerk. Crystal Robinson. Good morning, ma'am. Are you Crystal Robinson? And Miss Robinson, did you get a job? Where all have you looked?
I'm to 7 different places. I wrote down papers where I applied to. Me is kind of hard. I have a disabled son, but I guess also doing something apply for.
Right.
And
And I can see that you have a list there. Miss Robinson, thank you for doing what I asked you to do. I'm gonna have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. You need to fill it out accurately and completely, because you're gonna swear under oath that it's all true and correct, okay? All right, step in front of the, ma'am.
Did you want me to like the lawyers you told me to talk to as well?
Say it again.
You told me to talk to lawyers.
No, well, no, I appreciate that you did that also, and the main thing obviously was to try to get a job first, and it looks like you tried to do that. Yes, ma'am, Pages. So I appreciate that. Step in front of the clerk on the end, and she'll give you your paperwork to fill out. Yes, ma'am. Simranjeet Singh. Good morning. Are you Simranjeet Singh? And Mr. Singh, were you able to get a lawyer hired? Who'd you talk to?
I talked to the Franklin and the Cransford.
I can't understand you. Speak
Uh,
loudly.
I have one is Eric Franklin and Nathan Knowles, and one is Cransford.
Okay. And so where are you on
They all
the,
are like out of my budget.
are you working?
Yes,
Okay, where are you working?
I'm working at a gas station in Port Arthur.
In Port Arthur?
Raceway.
Okay. And do you work full-time?
Yes.
All right. I'll have you fill out some paperwork this morning. You may or may not qualify. You might just need to talk to some more attorneys, but I'll let you at least fill it out and I'll take a look at it. Step in front of the clerk on the end. She'll give you that paperwork. Tiffany Elair. Good morning, ma'am. You're Tiffany Elair. And Ms. Ealer, did you get a lawyer hired?
No, I'm supposed to be paying the institution, like the cash to pay the institution.
Okay, yes,
So, I'm sorry.
it's okay.
So she's on the initial or designation.
Uh-huh.
I've talked to the prosecutor about being able to pay restitution for dismissal. She has the money today, but I think she probably needs to get a cashier's check instead of cash.
Oh, okay.
And so
Let me just, you wanna,
if we can hold that.
yeah, I'll hold it. You can talk with Mr. Smith when he gets down here. Just say, Mr. Parker will tell you what you need to do, okay? Thank you, ma'am. Thanks, Mr. Parker.
Barbara, thank you for the $5. Ellie, thanks you. We will, of course, add that to the Trito Fund. So, again, thank you.
It's an initial. Yeah, it's an initial.
All right, we'll swing back to Judge West in a little while. Let's go back up to Michigan. Judge Prill, new contestant.
26, 7408 FH, time of day, section sentencing. Ms. Clark is present, represented by Attorney Dallas L. Rooney. People are represented by Prosecuting Attorney Timothy J. Rakowski. Back on March 9th of this year, the defendant entered a no contest plea to embezzlement, $50,000 to $100,000. Ms. Karen Everland's prepared the pre-sentence report dated April 20th of this year. Mr. Rooney, have you and your client had the opportunity to review the pre-sentence report?
We have, Your Honor.
Are there any additions, deletions, corrections, or objections to the report?
None of the report and none to the guidelines either.
Thank you. Ms. Clark, do you agree with that? Mr. Rakowski, any objection to the report as well as guidelines?
No, Your Honor. The other question.
Mr. Rooney, anything you'd like to say on behalf of your client before the court imposes sentence?
Yes, Your Honor. My client's 49 years old, virtually no criminal history. She had a DV deferral 23 years ago and a trespassing 15 years ago. Born, raised, lived her whole life here in the Thumb. Graduated from Akron Fairgrove. She worked for the ambulance board for 17 years. As far as the embezzlement itself goes, I think she pled no contest, but the narrative, I think, speaks for itself and lays out what happened. I would point out too that she was totally forthcoming with law enforcement when the detective interviewed her, admitted what had happened. So once they asked her, she was more than willing to say what she did, what happened in this case. With regard to the recommendation, we're asking you to adopt it. It did circulate some medical reports regarding her health, one of which coincidentally, one report is from the doctor who had some kind of contract with our jail, coincidentally. According to that doctor's office, that they believe that incarceration would impact her treatment plan and jeopardize her safety and well-being. Based on some kind of rare neural deficiency, I guess. So we would respectfully request home confinement or something along those lines with a tether, so that she can continue to do these medical appointments and treatments that happen periodically. As far as her addressing the court, I think she will address you briefly, but due to the no contest, she's really not going to get into the facts and circumstances.
Thank you. Clark, apparently you wish to address the court, you may.
I just wanted to say I'm really sorry for the terrible judgment I made. I'm trying to rectify that.
How do you plan to rectify what appears to be $146,000?
I plan on it until fair.
Thank you. Mr. Rakowski, anything on behalf of the people? This is a victim's rights case as well.
Mr. Honor, looking at the guidelines are 12 to 24. The recommendation for incarceration time is 320 days, which is below that. and I don't believe there's any circumstances that justify a departure downward. I would point out, as the court mentioned, it's $146,000 that the taxpayers from Seaboy Township area are out. It just seems like, I know the court has to fashion a sentence, and you're asked by Mr. Rooney to do home confinement because of the health concerns. I totally understand that. However, people that are out in the community see that 146,000 is missing from their township, the city. And so home confinement just doesn't seem to be enough, Your Honor. I would ask the court to fashion a fair and just sentence, understanding that there are other people that watch what happens and say, okay, well, you took 146,000 and this is what your sentence is. So they'd be looking at that part of it. I believe it's deterrence is probably the biggest part in this case, Your Honor. So we would ask you to fashion a fair and just sentence with that in mind.
Trusted public official working for an entity that is vital to the community. We are fortunate to have an ambulance services across our county that we have individuals that go out there, do the work, don't receive a ton of pay. Some are volunteers. And the whole idea is to protect our community in the event that we need someone called. And Seaboy Township, which covers the village of Seaboy as well, if we don't have an ambulance service, we're not helping our residents. And this entity needs to be properly funded. And to be properly funded, we take tax dollars, hardworking Americans, hardworking people in the area, in the village and the township of Seaboy, that have to pay that bill for public service. And to see someone over the course of a few years basically take away $146,000. It's unheard of. It's truly unheard of. This kind of reminds me of a case a number of years ago that actually I was assigned on an appeal. And I think this you probably know the case. The lady that was on the west side of the county. I can't think of her name, but Judge Knobloch sentenced her to a significant amount of time. And I was assigned on an appeal for her. I'm not going to mention the name, but the dollar figures were just through the roof, just like this one. She eventually went to prison. She went to prison. And the guideline range here is 12 to 24 months. And the court has reviewed the medical information. And it appears that there is a potential issue. But then the court can say, you know what, we're not going to put it on the county dime. We'll just send you to prison. Let the state pay for it. But we still pay for that as well. It's a no-win situation for the county. It's a no-win situation for the township. It's a no-win situation for the defendant. Other than, I don't know the reason or the understanding here of taking this money, but it wasn't yours. It wasn't yours. And we as public officials, whether it be the prosecutor's office, Department of Corrections, the sheriff's office, the court, we're entrusted with these dollars. And we make sure that they're not wasted, pilfered, thrown away, embezzled. Here they were embezzled to the tune of $146,000. And as an individual living in the township or living in the village, it puts a pit in your stomach like, how in the world can that happen? But it did. And it needs to be addressed. I don't know what an appropriate sentence would be at the end of the day for this. I know what an appropriate sentence would be under normal circumstances. punishment, deterrence, rehabilitation, all those factors play into it. But just taking all that money and running with it for whatever reason has to be addressed, and it has to send a message. Guideline range as stated is 12 to 24 months, which means that the court could sentence to prison. The court could impose county jail time, but at a minimum of 12 months. And the court has steadfast tried its very best to stay within the guideline range to provide consistency. And the reason for that is it doesn't matter whether you come in as some bright and shining star, or you come in as a regular individual or someone who is below regular individual. You treat the people the same. You have to. Because that's what the court is all about. We're blind. Lady Justice is blind for a reason. Blindfolded, I should say. Because it doesn't matter who you are or where you come from. This is a lot of money to pay back. And I appreciate the comments of the defendant indicating that some way, somehow, she's going to have to pay it back. I don't know how you're going to do that, but it's got to be paid back. Simple as that. As a result, the court is going to order, in this case, the defendant be placed on a term of probation for 5 years, not 3 years, 5 years. The reason behind the maximum amount of probation here is to assure that some sort of method can be come upon that is going to take care, or at least get this restitution figure down. Conditions of probation include the standard conditions: not to violate any criminal unit of government, not to leave the state of Michigan without prior approval of the court, notifying the probation agent at least monthly or such times and places the agent may require. The court will also order that the Thinking Matters program be completed. You are to waive confidentiality and allow any treatment programs you're required to attend and disclose that information to the agent. No assault of abusive, threatening, or intimidating behavior. No written, verbal, electronic, or physical contact with anyone housed within an MDOC facility without permission of the agent. Likewise, communication with anyone that's engaging in behavior that constitutes a violation of any criminal law of government. She's not to use any object as a weapon, nor own, use, or have under control a weapon of any type. Can't even possess an imitation weapon. Can't be around anyone that possesses those items. She's to contact the supervising field agent no later than the first business day following her placement on probation or release from jail. Comply with all written and verbal orders of the field agent. Allow the agent to your residence at any time of probation supervision where you're subject to a search of your person and property, including but not limited to your home, vehicle, or computer, without the need of a warrant if the agent is reasonable cause you of items that violate the terms of your probation. Any arrest or police contact, loss of employment, or change of residence must be reported to probation within 24 hours. You must not work in a position where you have direct control or access to another person's money. You are to make genuine efforts best you can to find and maintain legitimate employment, minimum of 30 hours per week, unless engaged in alternative programs approved by the Department of Corrections, and all the rules that follow along with that. Restitution, $146,000. I'm sorry, $146,007.31. That's payable to Sealing Township. You are to execute a wage assignment and pay that restitution if you are employed and miss 2 regularly scheduled payments. Crime victims assessment of $130, probation supervision fee $30 per month regular, $60 electronic. Court's waiving attorney fees. DNA testing of $60, state cost of $68. Probation is authorized and empowered under statute to effect your apprehension, detention, and confinement of up to 72 hours. On reasonable cause, you violate the terms and conditions of your probation. If referred, you must successfully complete any PA 511 programming based upon eligibility. Finally, you shall serve 365 days in the county jail. That's pursuant to the guidelines, with no days credit. How the court is going to do that is as follows. It sounds like there are medical issues and medical appointments that will be done during the week. She is to report to the jail Friday at 6 o'clock, serve weekends, be released Monday morning at 6 a.m. During the week, she's to be fitted with an electronic tether that allows home arrest only. She's not to be going anywhere except medical appointments or what the department deems is appropriate. In the event, and no disrespect, health gets better, which we hope it does, then the tether is gone. You're going to serve your time in the jail. The point here is the court is balancing the medical condition with the nature of the crime. This is a serious crime. And it's not easy to fashion a sentence when you have an individual with these medical issues because, you know, I hate to say, but it comes down to dollars and cents as well. For instance, if we place her in the county jail or even send her to prison, and these medical conditions need to be addressed, either the county or the state is on the dime to pay for that. We've already lost enough money. We don't need to lose any more money. And yes, it comes down to dollars and cents at the time, but your freedom is going to be impacted in a very significant way. You're going to get a taste of the county jail as well. There are no doctor appointments normally over the weekends. So that is the sentence of this court. It's my duty to inform you if you'd like to seek leave to appeal. If you're financially unable to provide counsel of your own choice, court will provide counsel for you at public expense. Please initial the receipt questionnaire form requesting the assignment of counsel, both of which must be executed under oath and filed with the court within 42 days. Also, that 42-day time period can also be filed with Max as well.
All right, apologize. Number 9, mental search.
Yes.
Thank you.
Yes.
She executed the same.
Record shall reflect the same. Your Lieutenant, is that doable at the county jail?
Better do.
You said Friday at 6 a.m. or 6
p.m.
6 p.m. 6 p.m.
Question for the court, restitution. Can the court add that due in 3 years? And then if it's not due, at least we have the review to come back to see where we're at on things.
That's a good idea. I'm going to order that as well.
3 years from
Payable
today.
in 30.
Or roughly. Yes, sir.
Thank you. We'll see where we're at with this. That'll be on. Off the record.
So Judge does raise a good point there. You know, Austin just said in the chat, she ripped off the city and gets weekend jail and 5-year probation. Yeah, but in the same respect, he's got a good point about the money end of things. If she's got these health issues that have to be dealt with and he puts her away for a significant amount of time, then the taxpayers are going to end up footing the bill for that health care. So it's one of these things where you got to weigh it out. Not a good situation all around, though, and obviously not a good person. So there's that. Let's head a little bit south, but stay in Michigan. Judge DeSanto.
Detective, if you can please state your name for the record.
Sergeant Devin Geiger, Wyandotte Police Department.
All right, thank you. And please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. All right. And so, Detective, you may proceed.
On May 1st, 2026, approximately 12:57, Officer Guzman on patrol and fully marked unit 74 traveling southbound on 4th Street near Pine Street. Vehicle is fully marked with Wyandotte decals and lettering, and she's also in a full police uniform with insignia and patch. While on patrol, she noticed a white Ford Fusion merged from lane 3 into lane 2 without using a turn signal. She also noted that the license plate cover on the vehicle made the plate ineligible to read. Due to these circumstances, she attempted to make a traffic stop with emergency lights on. The vehicle continued to travel, not pulling over or getting into the right lane, continuing to go the speed limit. At this point, Officer Guzman radioed dispatch that the vehicle appeared to be doing a slow stop or slow roll as they were still traveling southbound, approaching Leroy. The vehicle continued to travel southbound on 4th Street, approaching Quarry Road, when she noticed the Fusion to accelerate to speeds of 60 miles per hour, despite being in a 45-mile-per-hour zone. It was at this time that Officer Guzman recognized that the vehicle was attempting to elude her, and then activated her sirens as well. The vehicle continued southbound 4th Street until they would turn on a westbound on the Pennsylvania Road, completely disregarding the red signal despite heavy traffic. The Fusion continued to travel westbound Pennsylvania Road, reaching speeds excess of 77 miles per hour. The Fusion then turned northbound on McCann Street from westbound Pennsylvania, reaching top speed of 60 miles per hour in a 25-mile-per-hour zone while passing both Allen Elementary School and Southgate High School. The vehicle continued to drive recklessly throughout the pursuit, disregarding all traffic control devices, going off-road and driving high rates of speed. Chase eventually led to 16500 Quarry Road, which is Southgate Apartments. It was at that point the vehicle is reported to have purposely crashed into the lobby doors of the building, where the occupant exited the vehicle and fled on foot immediately. After crashing into the building, officers gave pursuit. At this point, Sergeant Gardaki, who was also involved in the chase, began running after the suspect and announced or gave orders for the suspect to stop. The verbal commands were disregarded. Sergeant Gardaki then deployed his taser, which partially helped stop the suspect. He had to be tackled to the ground. At this point, he actively resisted, struggled with the officers. Officer Guzman also had to deploy her taser at some point. Officer Gardaki was actually struck with a taser probe during this process, during the struggle. At this point, eventually, the defendant, identified as Donovan Joseph Martin, was taken into custody, handcuffed, and then arrested. And he does have a expired license, Your Honor, and that's it.
Okay, upon examination of the complaining witness, the court does find that the offense charged were committed and that there's probable cause to believe defendant committed those offenses. And counsel, your appearance, please.
Good morning, Your Honor. Attorney Corey Westmoreland, appearing on behalf of Mr. Donovan Martin.
Mr. Martin, your name for the record, please.
Donovan Martin.
Okay, counsel, as to arraignment.
Yes, Your Honor. At this time, we are prepared to waive a formal reading, and my client stands mute.
All right, the court will waive the formal reading. Sir, you do have the right to have an attorney. If you are unable to afford one, you may have one appointed to represent you. And you did, in fact, have an opportunity to speak to an attorney today. Is that correct?
Yes, ma'am.
All right. The court has also signed the petition in order for appointed attorney for felony matters. And sir, you have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury. You also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights, sir?
Yes, ma'am.
The court's going to enter a plea of not guilty on your behalf. We will schedule this matter for probable cause conference on May 14th. 10:40. At 10:45 a.m. And counsel, as to bond.
Yes, Your Honor. I would like you to know that Mr. Martin's currently residing in Southgate. He's not currently on probation or parole. He has no other pending matters that we're aware of. And after speaking with Mr. Martin at length this morning, he did assure me he would be appearing at all future court dates. And he does understand the importance of doing so. I would just ask that all that be taken into account.
All right. So, Mr. Martin, where do you work?
I'm not working at the moment.
When's the last time you were employed, sir?
About a month and a half ago.
And from where were you employed?
I was a server at Oga's Kitchen, Lathrop Village. I had another job lined up, but then all of this happened, so I haven't been able to call or do anything.
When did you have the jobs lined up, sir? Because this just happened Friday.
Like 2 weeks ago. I was supposed to do an interview for a new job, but I never made the call.
Oh. All right. And sir, are you currently on probation or parole anywhere?
No.
Not at all.
Not that I know of, no.
Okay, what happened with your matter out of Farmington Hills? January of 23, it shows you were bound over to circuit court for felony assault with intent to murder or commit great bodily harm less than murder. and felony assault with a dangerous weapon. What happened with that, sir?
I told my attorney that I did do a failure to appear on that. And I was just been trying to find an attorney to help me with that case. That case is against my boyfriend, who I am still currently with. So I just was trying to figure that out.
Well, sir, it appears as though you failed to appear for a probable cause conference or a pretrial. I don't know if those conditions were amended at circuit court, but potentially you're not even supposed to have contact with your boyfriend / victim in the matter. So there's that concern, sir. And it looks as though you have other failure to appears. Probation violation for malicious destruction of property, also out of Farmington Hills.
That was the only failure to appear that I was aware of, that I had told my Mr. Westmoreland about this morning.
Nope, there's a second one, sir. You're on probation for malicious destruction of property. And it shows that you have failed to appear in that matter, which appears to be from 2022. Who was the victim in that matter, sir?
John Bell.
Is that the same victim in the other matter you're just stating?
Correct.
Do you have any? Oh, and Mr. Bell was with you in the vehicle?
For this situation?
Yes,
No, he was not.
he was not. Detective, would you like to address bond?
I have great concerns for this case, Your Honor. Multiple lives were at risk during this chase, going through red lights, going through stop signs, passing 2 schools that were in session, disregarding multiple traffic and control devices, then crashing a vehicle into a lobby, nearly striking a vehicle that was occupied. And one of our officers was struck with a probe during this incident. With the warrants from 2022 or 2023 with great bodily harm, I just concern for the public. So I'd ask for at least 100,000, 10%, and a GPS tether, since the warrants are at least, it looks like 3 years old. So not to operate a motor vehicle, no weapon.
Okay, thank you. So, sir, is Mr. Bell a Wayne County Sheriff's deputy?
Yes, ma'am, he is.
Yes, okay. And so that seems to be why his name is in here, because apparently he pulled up on scene.
Yeah, he pulled up in a separate vehicle. He was in the car
Yes.
with me.
Yes, I see that. Well, the court has significant concerns for the safety of the public as it relates to Mr. Martin and his actions that bring him before the court. Significant concerns. Not only are the allegations that Mr. Martin was driving at excessive speeds in residential areas and school areas. However, it appears as though there's continued concern based upon the allegations that Mr. Martin drove into the apartment building, and then even from that attempted to leave as well. Mr. Martin also, based upon his the charge that he's currently on the warrant for assault with intent to create bodily harm less than murder, the court also has significant concerns. So what this court's going to do is this court's going to find that a $75,000 cash 10% or surety bond. I'm sorry, no, there's no 10% cash bond. In the event Mr. Martin does post bond, Mr. Martin is not to operate a motor vehicle at all, even if his license is no longer expired. Not to be released without a GPS tether to the Wayne County Jail. Not to have access to any firearms or weapons. Do you have any of those, sir?
No, ma'am.
Do you have access to any of those, sir?
No, ma'am.
Do you and Mr. Bell reside together?
No.
You're not to possess or consume any alcohol or drugs that are not prescribed. And we will see you back on May 14th.
Thank you, Judge.
Thank you.
Thank you.
Have a good day. Okay, Jeremy.
Alrighty, friends, good morning once again. TCF Live. It is May the 4th, Star Wars Day. So I wanted to point something out, which would apply to this guy that we just saw. He used the T word, try. So I would point you to the right side of your screen, right over there, where our friend Yoda says, do or do not, there is no try. I think, quite honestly, most everybody that we see today could benefit from that advice. Quite honestly, as all of us could. We probably default too much to the whole try thing and not enough of the do thing. So, just saying. Alrighty, let's go. Oh, do me a favor. So, dialing in a lot of stuff here because I changed a ton of things here in the studio over the weekend. Let me know how my personal audio sounds, too quiet, too loud, anything like that, because that was one of the things that I made a lot of adjustments to. So help me dial that in if you'd be so kind. Let's do Texas, Judge Stevens.
Involving Jeremiah Jean Foray. Is that you?
Yes, sir.
What's your name?
Jeremiah Jean Foray.
Jean.
Yes, sir.
Jean.
Yes, sir.
That's pronounced several different ways, but you pronounce it Jean.
Yes, sir.
And you were here with Mr. Dusler, your attorney, and the state's attorney. Does the defendant waive formal readings of this first amended motion to revoke unadjudicated probation and the new case, a third-degree felony failing to comply with sex offender registration requirements? Can we proceed in summary?
Yes.
Let's take this new case, substantive case 26 CR 190. In summary, this indictment handed up by the grand jury on February 4th of this year alleges that on or about August 25th, 2025 in Jefferson County, Texas, you committed the third-degree felony of failing to comply with sex offender registration requirements. Do you understand what you're charged with?
Yes, sir.
Explain now. This is a third-degree felony. If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached in your case. You would be pleading guilty, sentenced to 8 years in prison to run concurrently with 23-41590, which is a motion to revoke probation that we're going to go to next. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this indictment? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty. That's a yes
Yes,
or
sir.
no,
Yes, sir.
so, yeah. Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily, understand it, discuss it with your attorney?
Yes, sir.
Or the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered and
No objection.
without objection admitted. This states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true. It states so help you God. Correct?
Yes, sir.
States Exhibit 1, part of the record for all purposes. Pre-sentence report. Yes, I am going to follow this agreement. If nothing further, I'm going to find, sir, you are pleading guilty voluntarily. You are mentally competent to do so. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of this third-degree felony of failing to comply with sex offender registration requirements. I now find you guilty beyond a reasonable doubt of this third-degree felony. I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 8 years. You understand what has happened today in this case, sir?
Yes, sir.
Let's go to this 22-41590. This is a motion to revoke, first amended motion to revoke probation filed on March 17th, 2026. Are we ready to move forward on this?
Yes, sir, we are.
Does the defendant waive a formal reading of this first amended motion to revoke probation from the preceding subject?
Yes, sir.
And raise your right hand, sir. Do you solemnly swear or affirm any statement you make during this hearing on this motion to revoke probation shall be the truth, the whole truth, and nothing but the truth, so help you God?
Sir.
Yes, speak out so she can hear.
Yes, sir.
Okay, lower your hand. In summary, this first amended motion to revoke unadjudicated probation states that in this criminal district court of Jefferson County, Texas, on June 9th, 2025, last year, you were placed on 10 years deferred or unadjudicated probation for the second-degree felony of indecency with a child. Do you understand that is being alleged, and is that allegation indeed true and correct?
Yes, sir.
Yeah, if we just go to number 10, that's the new case.
Number 10, first amended, and this motion to revoke probation on the violations group 10 states that you committed the offense of failing to comply with sex offender registration on or about August 28th, 2025 in Jefferson County, Texas, which was a violation of condition 1 of your deferred or unadjudicated order. You just pleaded to that and you were found guilty to that. Is that allegation true and correct as it is alleged?
Yes, sir.
Are you pleading true and correct to this voluntarily and because it is true?
Yes, it is true.
Do you understand that a voluntary and truthful made plea of true to one or more violations of probation, that is enough to grant a motion to revoke probation? Your probation in this case can now be revoked. You can be found guilty and sentenced up to the full range of punishment. A second-degree felony carries with it no less than 2 nor more than 20 years confinement in prison. Do you understand the consequences of this?
Yes, sir.
Knowing all of that, do you insist on pleading true today to this allegation of a violation of your probation?
Sir.
Find you were pleading true voluntarily. You understand and appreciate the consequences of pleading true. There is an agreement that's been reached where your probation would be revoked. You would be found guilty of this underlying offense of indecency with a child, and you would be sentenced to 8 years in prison to run concurrently with the previous case that you just pleaded guilty to earlier, and that's 26, let's see. This is written wrong. It would be 26 CR 0190. Is that your understanding?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this allegation?
Guilty.
Are you pleading true as well as guilty? Voluntarily and because it is true as it is alleged.
Yes, sir.
I'm going to show you here what's marked as State's Exhibit 1. Did you sign this document, understand it, discuss it with your attorney, or the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into notes without objection and submitted. Among other things, this states, if I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
You just need to sell that right above on that council. Yes. Anything to add?
No, sir.
If not, I'm going to find Mr. Forey, you are pleading true to allegation 10 of this first amended motion to revoke unadjudicated probation filed in this cause number 41590 on March 17, 2026. You were doing this voluntarily, knowingly, and you understand and appreciate the consequences of pleading true. There's enough from your plea of truth to support this motion to grant it by a preponderance of the evidence is greater. This first amended motion to revoke unadjudicated probation is hereby granted. And as to allegation number 10 and your deferred or unadjudicated probation earlier rendered in this case is hereby revoked. In that earlier case on June 9th, 2025, when the court sentenced you to deferred or unadjudicated probation for 10 years, you had pleaded guilty at that time to this underlying offensive indecency with a child with second-degree felony. Voluntarily, you were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in that hearing to find you guilty beyond a reasonable doubt. Now that your probation is hereby revoked, I hereby find you guilty beyond a reasonable doubt of this underlying indecency with a child, second-degree felony case as a placement probation plea. And I find you guilty, and you are hereby sentenced in accordance with this agreement to confinement in the institutional division prison of the Texas Department of Criminal Justice to serve a term of 8 years. This will run concurrently with the previous matter that you pleaded guilty to earlier today. Do you understand what has happened in these two cases, sir?
Yes, sir.
Anything else to add?
No, sir.
All right, we are in recess on these two cases. Thank you. You will be given credit for all time you have served in accordance with these cases.
Alrighty, friends, I will keep an eye on Judge Stevens' courtroom. We'll probably go back there later. Just about 2 hours in almost, so about halfway there. Let's go to Lake County, Ohio. We saw Judge Culotta earlier. Let's check in on Judge O'Donnell.
Thank you, Your Honor. We're here this morning in the state of Ohio versus Carlos Jackson, case number 20 CR 214. The defendant is present, open court with his attorney, Mr. Deeb. On September 30th of 2020, the defendant did enter a plea of guilty to count 2 of the indictment, trafficking in cocaine, a felony of the 4th today. We are here today for the purposes of sentencing. The defendant has 81 days of jail time.
Mr. Deeb. Your Honor, we're prepared to proceed today at this time, and my client would like to address the court at the time of sentencing. Go ahead. Your Honor, back in the time of this offense, Mr. Jackson was using cocaine. He was in the throes of becoming a significant addict, and the addiction was increasing. So as part of that, he had stopped using. There was COVID at the time. He had some issues with his uncle. He was having trouble supporting himself up here. And at that point, after he had turned himself in February of 2020. At the beginning, in January of 2021, still during the COVID times, his uncle, who had had several strokes and is in significant health concerns, plus he has significant resources in the family, were trying to take advantage of that medical situation and to take advantage of his finances. Mr. Jackson went down to Columbus and started to be his primary caregiver, and he worked over 15 jobs, and he stayed out of trouble down there. And because of his issues with his uncle, he has been focusing on that, and he's going to be acknowledged as his caregiver to receive resources from the state of Ohio, because he's been cooperating with the Department of Job and Family Services as far as helping with that care. At this time, he made contact with my office, made arrangements to turn himself in, and we are thankful that he is in court as quickly as he is. We appreciate the timing of that. He would like to address the court to explain the circumstances that led to the significant delay in what was going on. And he has since, he did test positive for marijuana. We knew that he would test positive for marijuana. However, he has stopped his use of hard drugs, such as cocaine, and he has been focused on taking care of his family down in Columbus. But he did make the trip up here to resolve this. As far as whether there's a Cuyahoga County case, we do speak with the prosecutor. He has a hold that's listed on the jail. However, we don't have any information regarding whether there actually is a case, and he believes that there is not, because he believes he hasn't been in any other trouble since this occurred, and this was the only offense that was outstanding as far as he can recall. So we'll get to the bottom of that Cuyahoga County case. And with that, Mr. Jackson would like to address the court to tell you about what's been going on with him since 2020 until the present.
Okay, Mr. Jackson, what do you want to tell me?
You can have a seat and talk to the judge. No, you can have a seat. Just make sure you
Good
keep your
morning.
voice up.
Good morning, Judge O'Donnell. And since 2020, I'm not perfect. I went down there because it's more job opportunities in Columbus. I worked about 15 jobs. My last recent job was at Southern Glazers. I was driving a forklift for 2 years, and I got fired because of my transportation. To get there, I stayed with my uncle. He got 4 dogs, and I get him to all his doctor's appointments. I get him dressed, help him get in the shower. I got a 6-year-old daughter that I can see. I've been getting fired from jobs because of my warrant. So when I work as a temp, for 4 to 6 months, and it's time to hire you on, the warrant pop up. So I got sick during COVID and actually caught COVID, and I didn't think that I was going to make it. But I learned down there working and staying out of trouble. I got a 6-year-old daughter named Samaya Summerall that I'm blessed with. I'm not a bad person. I just want to work. I want to get into the trucking business. I haven't caught a case in 6 years. I don't do drugs at all.
Well,
marijuana, but I'm done with that. I really just
marijuana is a drug.
Yeah, it's just marijuana, but I don't want to put that behind me. I just smoke cigarettes. I don't drink or nothing no more because my uncle is kind of my main priority because he been there for me, so I take care of him. And I had to tell him that I had trouble up here because he never known, even though I make him my responsibility. He didn't know that I was in trouble years ago on top of me taking care of him. So I told him I want to be great. And he wondered why I couldn't be his caretaker, and I get fired from jobs because my background keep coming up after I worked 4 to 6 months as a temp. Trouble is not my name no more. I love being a citizen, working, but this warrant been hindering me for years. And I knew in order to be great, I had to take care of it. I love working. I love interacting with coworkers because my work ethic is very good.
Your Honor, I didn't inform you, when he brought up his daughter, Samaya, he is in touch with the mother. He does visit with his daughter. He has, not custody, but he sees her all the time, and he is helping support her. And the mother does know of this situation currently.
She said she was proud of me that I took care of her because I told her I've been wanting to be in my daughter's life more, but I don't stay here because I'm not in contact with no old friends. It's just my uncle, the dogs, and I cut grass. We got lawnmowers and stuff. He just had a stroke. His hemoglobin got down to a 3. So when the police had came to our house, because they couldn't get in contact with him. They said that he could have passed, so we rode in the ambulance to the hospital down there, St. Anne. And I stayed there with him every day. He had to get treatment in the nursing home for 21 days, so I had to go over there every day, bring him fresh fruit because I'm all he know.
So, Your Honor, what we would ask is if he could be placed on probation for whatever period, up to 5 years, this court would see fit. We know it's been an extreme long time, and people shouldn't benefit from having the warrant outstanding, but he's taken strides to improve his life and to better himself. And he would like to be there for his uncle so that he can move on beyond that and get a good job now that the warrant is gone, and he can work towards his license, because that has affected both of those, so that he could get back on the straight and narrow. And if supervision were transferred down to Columbus, he would have that accountability and to show this court, not through his words, but by his actions, that he has changed his life along the lines of a law-abiding citizen.
The biggest problem that you have with everything you said is I don't know if any of it's true or not true. Because you ain't been around for 6 years, right?
Yeah, I gave my lawyer my address where currently all my mail go there, 6300 Carl Road, Columbus, Ohio. I don't have nothing to hide.
So the next biggest problem you have is why should you get the benefit of having disappeared for 6 years? Because you, just looking back at your history, you've got an unauthorized use of a motor vehicle in 13, a drug possession misdemeanor in 13, trafficking in heroin in 14, you went to prison. Trafficking in cocaine in 16, and you went to prison. There's an unauthorized use of a vehicle in 19 in Cuyahoga, which apparently you pled by telephone and got probation. Then you got this thing that occurs in 19 and 20. And so you plead guilty to the F4. We do a pre-sentence report and you don't show up. So why didn't you show up for the report?
Because around COVID time, I told you I had court COVID and I was mentally sick.
Okay, and then what did she tell you back? Do you remember what Ms. Randazzo told you when you called and said you were sick? You probably don't, because it's 6 years ago. What did he tell you?
Colvin stating he was sick. I told him I would reschedule him to send me in verification of seeing a doctor, and I would reschedule. I also spoke with his attorney, and no verification of any doctor's appointments were ever sent to me, and I never heard from him again.
And around that time, I had a few deaths in the family, which is not an excuse. But over the last 6 years, I learned that I can be a normal citizen and without drugs involved. That's besides me. I just want a fair opportunity to work and be a normal citizen.
Well, you said you got fired for transportation issues. What do you mean?
I couldn't get back and forth to work. Like I was riding in the carpool with other coworkers because every job I worked at, they see my work ethic, and you know what I'm saying, they see me striving to get to work every day, and then my transportation got messed up, and the job was kind of far from the house. So I take any job I can get out there. All my jobs been warehouse.
Well, what was it? I mean, what do you mean a transportation issue?
It was too far for me to get. Like I was working.
Why don't you have a license?
Because I got a warrant. I can't get my license until this been resolved. Like I couldn't do no driving job because
Why didn't you resolve this sooner than 6 years later?
Scared, stressed out. I got a daughter. You know, I've been thinking about it every day because it's been hindering me from working. I've been wanting to resolve it. That's why I thought about it every day. I know that I ain't perfect, and I know that I can't afford to be in trouble while I'm already in trouble. I just wanted a fair chance over these years, I got a chance to work and meet working people and know that it's more to it. That's why I don't live in Cleveland. I got my daughter and my mother here. That's a diabetic and sick.
Where does your mother live?
My mom live in Euclid. She a diabetic and got other medical issues. And then I got my uncle in Columbus. So I don't come to Cleveland because, you know, that's my old life. I just enjoy, I cut grass down there when I can because I've been getting fired from jobs as a temp because of my background pop up. So I work 4 months somewhere and then it is show that I have a warrant and they say I could come back and work for the company when I fix it.
What's your uncle's name?
Robert Story. He's 84 years old, just turned 84 April 7th.
Okay, and what's his relation to you?
He's my mom's father brother.
Your mom's brother?
Yeah, my mom's father brother. So he's my great uncle.
Okay. And besides 6 years ago, when did you have contact with him before that?
I would see him when we come down to visit. But
Who else lives in Columbus that's related to you?
It's just me and my mom. I was living with my mom's sister, Miranda Jackson. She passed away in 2023, and he needed care from me because he didn't have nobody to care for him.
Okay, well, why did you
I was working with her.
When did you go to Columbus? You didn't show up here in September of 20. When did you go to Columbus?
In 2020, because I couldn't find no good jobs there. My first job was $19 an hour when I got to Columbus. All the jobs I was looking for here.
When?
Around Christmas time, maybe, of 2020, Thanksgiving, Christmas.
You told me after Christmas, I put January of 2021.
Yeah, around Christmas.
Doing what?
My first job was pick pack in the warehouse, pick packing, putting stickers on the boxes on the conveyor belt.
Where else did you work?
I worked at DSW at the shoe factory in Columbus on Fifth Avenue. I worked there for 6 months until it was time to hire on, and then they had to let me go.
What were you doing there?
We was boxing shoes and put them on a conveyor belt, and then the forklift would come get them. My longest job was at Southern Glazers. I was driving a cherry picker for 2 years. So it's been all warehouse jobs, because I like warehouse work. But that's the only jobs I could kind of get.
Okay, Ms. Contour?
Thank you, Your Honor. The defendant did plead guilty to a F4 in September of 2020. He went to probation, tested positive for cocaine and marijuana, violating his bond. He then did not complete his pre-sentence report, and he has 2 prior prison terms, so none of those things recommend him for community control sanctions at this time, and we would recommend prison.
You don't think you have this case in Cuyahoga?
Your Honor, based on what you had stated, it sounds like it's a probation violation, and that might be the warrant. If he was on probation and then he left, that seems to be, does that sound?
I wasn't on probation. They were doing COVID.
That says no probation.
Okay.
They were doing COVID. They did everybody.
I was speculating, so if he wasn't on probation, that can't be it.
Your Honor, in the time we've been sitting here, I had our office run his leads this morning. It does not show a warrant. The only thing that it shows is on the jail roster, it shows hold.
Okay.
And I was looking at his warrant on the leads from 2020. He did have a warrant for grand theft at that time,
Right.
but it did not show one this morning.
Thank you for clearing that up, Ms. Contour. Goes along with what you were saying.
All right, so that, okay. What's your address?
6300 Coral Road, Columbus, Ohio. Zip
Coral?
Code, Coral, K-A-R-L Road, Coral Road. Zip code 43229.
What kind of residence is that?
It's a multi-family house, 3 bedrooms up, 2 bedrooms down.
Who lives there?
Me and my uncle Robert Story, and the 4 dogs. My uncle sleep on the couch because he don't sleep on the bed. So I sleep in the front room with him because I got to make his medicine.
Who's there now?
My cousin Michaela, she graduated school this year, so she's kind of helping him out because I'm the nephew. I'm always there with him. I make sure he okay, do his blood pressure,
How's she your cousin? What's the relation?
Her mom passed in 2023, Miranda Jackson. My auntie I was living with while I was working at her house. She was renting a house from my uncle.
Okay. All right, here's what we're gonna do today. I'm not gonna sentence you today. I'm gonna sentence you at a later date. Let me see, the three of you in here for a minute. And you too.
Okay.
Okie dokie then. They're going to go back to chambers and he's not going to get sentenced today. So I guess that is that. Let's, but I'll keep an eye, just in case something happens of significance. But let's go to Texas. No, actually, let's not go to Texas. Let's do this first. So one of the upgrades that we made to the studio over the weekend was we added a brand new cat tower for Ellie and for Io. This was just a few minutes ago of her sleeping on the top of the tower, which might mean I'm going to need to relocate the cat camera, the Ellie cam. So we'll see how well she takes to it. But this might be the new home during the show. So we'll see how that goes. Anyways, with that having been done, now let's go to Texas and say good morning to Judge Boyd.
Just Odyssey is acting crazy today.
I haven't heard that before.
So hopefully it will work now. All right, the court is calling 2025 CR 001529 State versus Tony Rodriguez. Can I have parties announced for the record?
Brandon Prada for the state. Scott McCrum for Mr. Rodriguez.
And are you Mr. Rodriguez?
Yes, ma'am.
All right. Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it? Are you the same Tony Rodriguez who was placed on community supervision in 2025 CR 001529 for the offense of possession of a controlled substance, penalty group 1, 4,200 grams on June 26, 2025 for a term of 5 years? Is that you?
Yes.
All right, state.
Judge will be proceeding on violation condition number 4, specifically that in Bexar County, Texas, the defendant, Tony Rodriguez, did then and there fail to report to the supervision officer as director for the months of October and November 2025 in violation of condition number 4.
How do you plead to that? True or not true?
And judge will also be proceeding on a violation of condition number 6, specifically that on or about the 12th day of September 2025 in Bexar County, Texas, the defendant, Tony Rodriguez, did then and there fail to consent to a search of his person, residence, or vehicle in violation of condition number 6.
How do you plead to that? True or not true?
And we'll waive the remaining violations.
Any objections to the waivers?
No, Your Honor.
Did you understand by pleading true to violations 4 and 6, the court could find it true, grant the motion, and sentence you up to 10 years in the prison? Knowing that, do you still wish to plead true to 4 and 6? You still wish to proceed with that?
Yes.
All right, the court will find violations 4 and 6 true. Is there a proposed agreement?
Yes, Judge, the
No, we're not.
oh, we're not agreeing.
We're at 100%.
Okay, Judge, we do not have agreement. The state has this recommendation.
All right, state, what are you requesting?
Judge, we're requesting that you revoke the defendant, sentence him to 6 years TDC.
All right, in defense, what are you requesting?
Judge, we're asking if the court would consider going along with probation's recommendation of SADF to stay in custody until he goes to SADF treatment and ISF to follow.
the way the report is written was a little confusing. I misunderstood what it said about him absconding, and I think Mr. Prater did as well. We thought it meant that he went to ISF and absconded from there, or just never showed up to ISF. In reality, what happened is he stopped reporting after he took the TAP evaluation. He never knew he was ordered to ISF. Doesn't excuse that he went AWOL, but he didn't run from ISF. He's never had a long-term inpatient treatment. He said the longest he's had, I think, was a 40-day stay or something like that at Lifetime. He knows he has a problem. He wants to address the problem. He's very motivated for treatment. He's sorry that he's in front of you again, but because he's never had that kind of treatment before, I'm hopeful that you'll consider that.
All right, he's been missing for like 8 months.
I don't know how long.
I mean, since the violations that he pled true was that he failed to report October and November 2025. So why is he not reporting?
He started using again, Judge, and I guess he could address that better than I could.
All right, does he want to address it?
Sure.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Tony Rodriguez.
All right, anything you wish to say?
Just that, I understand I stopped reporting. I been at the address I was given, and no, it's not enough, but that's where I was picked up at. Because been picked up any time at that address, and I know I need any help.
Well, no. Why didn't you report? That's what it seems to me what you're telling me is you're pushing, you're not reporting off of somebody else, like I've been at the address, but you knew you had to report, right?
I had to report.
So why did you not report for these many months?
I wasn't ready to commit the truth. I have home issues. I'm not putting it out on nobody. This is mine. I get that. But I had issues at home and I wasn't ready to figure this out with the family help that I have now. Everything at home is taken care of. And I couldn't worry about myself right now. You know what I'm saying? And
did you start using again?
I was using,
And what is up with this? Not allowing them to search your person or your residence, because obviously if you're pleading true to not allowing them to search your person or your residence, that means, and I'm making an assumption here, and if my assumption is incorrect, let me know. That seems to suggest that they came to your house wanting to search and you told them no.
They searched and they found smoking devices, and I was using, so I would have had a little bit more of substances. Your assumptions are correct.
All right, just one moment. Is anybody's Odyssey not working properly?
Not working.
Thank you. I just wanted to know if it was me, because technology and myself are not very well. All right, so continue.
No, I mean, it was I stopped the search after they found the smoking device and pipes there, and had they continued searching, they would have found a little bit more drugs, you know what I'm saying, too, that I was using, and I stopped the search, I guess, at that point.
All right, does anyone have the trial court summary?
Have the court summary, Judge.
Any objections to the court reviewing that?
No, Your Honor.
All right, thank you. Let me see, they're telling me to try Odyssey now.
Working out, Judge.
All right, I've had 2 people say it's working now. We're gonna see. Sorry. Slowly, let me see if it will let me in. And see, I kept telling everyone, what happens if Odyssey fails? And they're like, oh, it'll never fail. Okay. All right. Did you ever enter lifetime?
Before I got sentenced, yes, ma'am. You requested, after the day I got sentenced, that I go back into lifetime. Probation said that there was no more funds for that.
Mhm.
And that's why I was trying to get into, I guess, any kind of program at the time.
All right, I'm going to give you a choice. These are your only two choices. Don't ask for a third. One, I'll revoke you and I'll sentence you to 4 years in the prison. Your other option is I will continue you, but you're going to safety. Those are your only two options. Which do you prefer?
Safety is the 9-month treatment, and you might have to wait a few months before you get to that. Can I get the 4?
All right, see? Sometimes people won't help.
The
Sometimes
deal
people won't.
maker, Judge.
No, I mean, I'm just, All right, the court will grant the motion. I'm sorry, are you waiving your right to appeal? All right, the court will grant the motion, revoke, and I'm sorry, state you may be excused.
Thank you, Judge.
Court will sentence you to 4 years in the prison. Give you credit for any time served. The court will request the therapeutic community. It doesn't increase the time that you're in custody, but it could potentially help you with any substance abuse issues you may have. There should be no unsupervised contact with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, good luck to you.
Thank you, ma'am.
You're
Thank you, Your Honor.
Not the first time we've seen that. It's rare, but we do see it where people will choose the time over the treatment. Know thyself, I guess. You know, I suppose if you've gotten that far down the road into all of this, I suppose you pretty much know who you are. So, wish them the best. Let's go back to Michigan. Judge Aquilina.
What's your shirt mean? 70X7.
It's a,
Huh?
it's a Bible. It's my auntie clothing brand. It's a gospel clothing brand. It means the Bible to give you 7 times 7 of your sins. That's what the Bible says.
That's very cool. I figured it meant something. Tell her I like it.
Thank
All right. All right, this is docket 26460FH, people of the state of Michigan versus Darnell Lavelle Thomas. Counsel, your appearance for the record.
Good morning, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
And good morning, Your Honor. Stephen Mills on behalf of Mr. Thomas. Mr. Thomas, present and staying to my right at this time.
Thank you. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide to be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Thank you. Put your hand down. Have you taken any medication yesterday or today, marijuana, alcohol, anything at all?
No, ma'am.
Is there anything you're supposed to be on that you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
Have you had enough time to speak with your attorney?
Yes, ma'am.
And did you review the pre-sentence investigation report to your satisfaction?
Yes, ma'am.
All right. On behalf of the people, aside from the sentencing date, which needs to be the 4th of May, throughout, what other corrections, if any, are there?
No corrections for the people, Your Honor.
On behalf of the defendant?
Thank you. Your Honor, the only corrections to the body, I guess, would if we should update the is Judge Buchanan is listed. I don't know if we should put Your Honor. She took the plea, Your Honor. I think that's why she was listed there in the felony plea district court.
That should be. Let me go out. Basic information sheet anywhere else.
Also on the cover page, Your Honor.
I've got on the cover page. It's not on the basic information sheet. Oh, yes, it is. I changed it there too. Okay.
I think just in the sentencing, the guidelines as well, Your Honor.
Oh, yes. Thank you. All right, any other questions?
No, Your Honor, thank you.
And what about the guidelines?
Not from the people, Your Honor.
None from the defense, thank you.
Thank you. There's a victim here?
Your Honor, let me double check. I don't believe so, but let me double check. Jessica Thompson? Go out in the hallway, 1 second, Your Honor.
Thank you.
No, Your Honor, there is no victim present.
Thank you. Counsel, what would you like me to know? And could you address, I have the recommendation from probation, 365 days jail, but I have the stipulation of county cap. There's a big difference between that. That's not a stipulation of a year in jail, is it?
But that's the limit, Your Honor.
Right.
Yes.
So their recommendation is the limit without any probation. There was no agreement to 1 year in jail, correct?
That's correct, Your Honor.
Okay. Thank you. What is the recommendation of the people?
Yes, Your Honor. I understand that it is a county cap. The guidelines are 19 to 38. So I do believe that it would be appropriate for Mr. Thomas to get some jail in this, considering the situation, considering the charges, considering his pretty lengthy criminal history, Your Honor, including multiple high severity felonies, numerous low severity felonies. So I would ask that he serve at least 6 months, Your Honor, with probation afterwards. Thank you.
Counsel?
Thank you very much, Your Honor. Your Honor, we are asking for probation in this matter with no upfront. And I think there's a very significant point to be made here, Your Honor, is that if the court looks at his criminal history for the past 6 years, he's not been in any trouble whatsoever. Significantly, what has changed his life is that, one, he had his son who was born, who he's been very involved with, as well as his father passing away, or at least his adopted father. Since, as PSI noted, my client was abandoned when he was very young, just in a vacant house, Your Honor. Even though the people bring up the fact that he has many felonies, and that is true, Your Honor, I'm sorry, many felonies, many convictions. If the court looks at them, largely they are retail frauds, larcenies, with a few R&Os where my client says that he has run, but he's not harmed anyone. And he was very adamant with me about that regarding him not being a violent person. This situation here, 6 years, no trouble, what happens? For a while, my client believed that he had a daughter with the complaining witness in this matter. And on that day, he found out that he was not actually the father, and he reacted very, very poorly. He did note that he did not punch her, and that's accurate, Your Honor. What happened here is he grabbed her by the lapels, Your Honor, which he shouldn't have done, and he's owned up to, honestly, sincerely, and recognized this. And I think that this is an important thing when it comes to him recognizing where his faults are. What he did wrong, admitting to that, owning up to it, and being able to correct what he can do moving forward, Your Honor. He is working. He is currently working full time at Hanks cuisine. So it's at least an update from when this was originally done, where he is a cook. He's also working at Douglas Supply, which has been his employer, fair to say, on and off for quite some time. But he is making sure that he can support his son, support his family. And this has been his pride, and this has been his driving force moving forward, which again has kept him crime free for the past 6 years. So, Your Honor, with that, I'd ask the court give him a sentence of probation. And if there's anything further, I'd leave it to my client. Thank you very much, Your Honor.
Sir, what would you like me to know?
First and foremost, Your Honor, I'd like to apologize to the state of Michigan and the city of Lansing. Second of all, I'd like to apologize to my family who can't be here right now due to the matter at hand. But the person you see on that paper is far from the man I am today. Like, when I had my son, I just did a whole 1440 with my life. I ain't doing 360, 720, none of that. I'm a father of a 7-year-old autistic son. I'm a son of a mother that's 80 who I take back and forth out of the house, medical appointments, go get her prescriptions, make sure she eat right, diet right. I'm also the father of a little girl who I recently found out ain't mine. That's kind of the reason we're here.
How old is she?
She's 9 now.
Okay, so do you know who the biological dad is?
I believe she do.
Well, let me ask you this, have you talked to an attorney about that?
I haven't talked to nobody about it because
Okay, let me stop you there. Is your name on the birth certificate?
no, ma'am.
Okay, so you were only putative dad to begin with, but there is, have you been supporting this child?
Since day one, I ain't missed a beat.
Okay, well, why isn't your name on the birth certificate?
I mean, so, all right, I was coming home, I was in the halfway house and I got a text from somebody telling me I need to call them, which is the person at hand. I called her. She was like, I don't know no other way to say this, but we have a child. And I was like, let me see the little girl, and I've seen her.
How old was she at that point?
I believe like 11 months, maybe a year, 11 months. And I
don't need to know the whole story. The reason I'm asking is because there is a statute where if a woman has led you to believe you were the father and you acted as the father the whole time and you have bonded with that child, you can actually still be the dad. It's up to you, sir, and you talk to a lawyer. Your name's not in the birth certificate, which may be a complicating factor, but there is a statute where you can, if you want to continue to pay for that child, see that child, and continue to be the dad in all respects, there is a statute that allows for that if you want to do that. There is no reason for you to beat up the woman because at 11 months or whenever she said, hey, you got a child, at that point, A, you know you had sex with her. B, she probably had sex with other people, same as you, and you could have had a blood test and you didn't, but you bonded with the child. There is an opportunity for you to continue being the dad regardless of what she says. That's up to you. See a lawyer.
I ain't got no intentions on leaving this little girl life. Like I said, I was beating foster homes till I got adopted. Somebody adopted me, loved on me, so I don't got no problem with that. Like I bonded with this little girl. Can't no man or woman break that bond that I got with her. So I'm gonna continue to do that.
No, you can't, because is that the child of Jessica Amanda Thompson?
Yes.
Okay, so there'll be a no contact order.
That's fine. I will stay
Sir,
away.
I'm trying to help you out here. Don't stand in the way of yourself again. Here's the deal. There's going to be, throughout this probation, a no contact order with you and Jessica, except for court. And if you go to court, you can't leave with her or ride with her. And be with her in the same courtroom with the deputy there and with the judge there. You can petition to have your name on the birth certificate, even though you're only putative dad, because you have formed the father-daughter relationship. She looks at you as a dad, you look at her as the daughter, and you would have to commit to the court to pay for the child, etc., just as a biological dad does. There is a part of a statute now. Your name's not on the affidavit of parentage or the birth certificate, so I don't know how the family court judge will rule. I'm not in that court. I used to do that work. And the law does provide for that because you two have clearly bonded as daughter, father. And it's in the child's best interest. And there's no other man saying I'm the daddy. So if you want to pursue that, you talk to a family law attorney, Mr. Milks. I don't know if you do that work or if you can refer him, but you can do that. But in the meanwhile, there's not going to be any contact with the mother except for legal proceedings. So if you don't want to see that child for a couple of years, then do nothing. If you think that relationship is important and you want to be the dad to continue doing everything you've been doing, then you need to take legal action. It's up to you.
Yes, ma'am. I understand, Your Honor.
Now, your attorney has said, you know, you're not a violent person. Well, you got a really bad criminal history. It's not the worst I've seen in terms of the charges, but you apparently don't like police and you've obstructed and put them in danger multiple times. You've had firearms in your possession. You've interfered or malicious use of telecommunications service. That tells me something. They've got assault and battery misdemeanor. You've had controlled substances, but it looks like you're sort of past that. You haven't done that in a couple of years, at least according to the law. I don't know what you've really done. And then there's malicious destruction of property or fire or police property. I mean, there is some, I beg to differ with you, counsel, in terms of him being a safe, nonviolent human. I think he's got some issues. I think they probably stem from his childhood, and we're gonna deal with that. And let me just say on behalf of the people, if you want to send someone to jail for 6 months or a year to make that part of the plea, don't tell me how terrible this is when he gets pled to county cap. Because that's just, there was nothing saying he gets any jail. That wasn't part of the plea, and I'm not going to give it to him.
And just to clarify, Your Honor, this was a plea done in the district court, not.
Well, the district court needs to have a lesson. I do not prefer that they do my pleas because they mess them up all the time. They have no clue what we're doing here. No clue. And so this, I'm not blaming you personally, but the message has to be sent because this is two different messages, and I have to weigh on the side of the defendant on this until he proves otherwise, and then it may not be jail, sir. I can send you to prison, and then you can go to your kids' graduations. So this is up to you. If you want to be the man that your kids need, stay on the right side of the law, have some respect for the law, for law enforcement, for your community. Because otherwise you're not wearing that fancy sweatshirt that I like so much. You can be wearing a jumpsuit. The choice is yours.
I understand.
Sir, you got 24 months probation. As to jail, you will serve 2 days, which you've already served, but you have 365 days. You'll serve the 2 days and the balance is held. So right now you're a free man as long as you comply with probation, do the right things, and are respectful. If not, you're brought before this court. I look at your record. Things might not go so well for you, sir. You have choices to make. You can either raise those kids in person, or you can write them postcards from prison.
Raise my babies in person. I promise you.
If I had a penny for every promise that was made there, I would be a very wealthy woman. I would have more money than Trump.
Get the timeline.
Well, no, I don't have to see the timeline because I got, what, 27 times or something that you've been in front of judges? Nonetheless, here's what I deal in. I deal in evidence. So you come back someday and show me the great things you've done. We'll take a picture with you and your kids, okay? You show them that you can get into some trouble, but you make amends and you learn. These are all teachable moments. This is the end of the road for your teachable moments, sir, because the next time you learn something, it may very well be in prison with the warden. You choose.
Yes, ma'am.
We clear?
Yes, ma'am.
Great. Because this is a gift today. You won't be getting another. Some judge is going to look at this down the road and say, my gosh, why hasn't he gone to prison? It's time. So you have 24 months probation. You shall not use, possess, consume, purchase, or be in the presence of alcohol, illegal drugs, or drug paraphernalia. If you have the need for any of those things, you'll present a prescription from a licensed medical physician within 24 hours. You will advise us of all medications you're on within 24 hours. That would include the psychotropic medication, if any. Doesn't sound like you're on any, but if you are ever on anything like that, you will take those meds as prescribed, only changing them with your doctor's approval, and work with your doctor. And again, let us know. You'll sign releases so that we can verify that you're doing what you need to do. You will take the long-term batterers intervention class along with cognitive behavioral. No weapons, no guns, no ammunition, not in your presence, on your person, under your control. You will allow probation to search your residence, cell phone, garage, vehicle, whatever they need to search if they believe that you are violating probation. That would be without a warrant. You will not have any assaultive behavior, verbal or physical, with anyone. When was the last time you used illegal drugs or alcohol?
I haven't used alcohol in 4 years, no drugs. in 4 years.
Okay, good. You will remain employed, and if at any time you're unemployed, you'll be part of a work seek program. You will not give your employer any cause to terminate you. They'll report to probation as often as they require, but no less than 1 time per month. You will keep us apprised of any change of address, cell phone, employment, personal protection order placed on you, contact with police. Do you understand that?
Yes, ma'am.
All right. You will pay $130 crime victims. You'll pay a $68 state cost. And tell me about your bills. Are you able to pay bills or not?
Barely.
Barely? All right, so I'm waiving probation oversight fees, and you can arrange a payment plan for the $198 that are mandatory. I'm waiving all other fines, costs, attorney fees. There'll be a continued no contact order with Jessica Amanda Thompson, except for court should he proceed to go to court for their daughter. And he will not be within 1,000 feet of her work, school, residence, or place of employment, or extended family. And again, the daughter would be at the once deemed his daughter, will be as required or allowed by the family division. But if he is in violation of probation, he will see neither child until he's compliant again, so that we don't put a child in harm's way. Additionally, sir, what's going on with you? Why are you so angry? Is it because of how you grew up? You didn't, what happened?
Well, I mean, to be honest, Your Honor, like, I just, like, if it wasn't for my kids, I know for a fact I'd be in front of you for something else. It wouldn't be this.
Okay, tell me why. You were not born to say, I'm gonna be the rest of my life in front of a judge. What happened? Do you know what happened in your life? What are you mad about? Huh? Being in foster homes?
I was beat, like beat.
Okay, so I want him to, as part of the treatment, whether it's in the domestic violence treatment or in the cognitive, I want him to go through trauma-based treatment. Sir, you gotta let go of some of that. Things don't happen to you, they happen for you. And now, how this works for you is to look at, okay, I suffered all these things. Now I'm gonna be the best citizen and dad I can be and stop with the anger. Because all that's doing is beating you down further. And I think you're ready to rise above. But you might need some help to do that. Because you have to come to terms with all of that stuff that should not have happened to you. And I'm sure there's a layer of anger there you're acting out. But the only one that's getting hurt, first and foremost, is you. And if you're not your own best friend, first, you can't help anybody, including your children. So let's get all these issues handled. Can you do that?
Yes, ma'am. Yes, ma'am.
Is there anything I've missed?
No, Your Honor.
No, nothing fast, thank you.
You have 42 days to appeal to request appellate counsel.
That's right, you are.
Waiting for you.
I know, well, not.
Oh, they're not there.
No.
No. Let me use the last one.
No, somebody just used the Elmo.
There were plenty on Friday. I don't know where they went.
Well, we were using the Elmo, they just got moved. They just have to be re-put everywhere. All right. So, sir, if you're unhappy with this, you certainly can appeal. You have 42 days. You acknowledge receiving that?
Yes, ma'am.
Okay, so go downstairs now and they can keep your appointments with probation. They do not chase you, you chase them. You need to change an appointment, you change it. Got any questions about what I mean?
No, ma'am. I understand.
Sir, again, this probation is for you. Jail is a punishment. Prison is a punishment. Probation is for you to heal and be a good part of our community and hopefully a role model to your children. The choice is yours. Good luck to you.
Thank you. Thank you.
It's TCF Live on a Monday, friends. May the 4th, Star Wars Day. I don't know if you noticed behind me, but I swapped out most of my Legos for the majority of our Star Wars Legos. Actually, I don't even know if it's the majority. Probably about 45% of our Star Wars Legos, honestly. But yeah, celebrate. At least celebrate what Star Wars used to be. I'm not sure what it is anymore, but it used to be something wonderful for sure. Anywho, let's go back to Judge Prill's court over in the Thumb, because he has somebody in front of him who is in an MDOC jumpsuit. You don't normally see them in the courtroom in MDOC attire, but here we are.
257274FH, time of day is for resentencing. The defendant is present, represented by Bickerstaff, who appears in the courtroom. And it's Kimberly A. Bickerstaff. People are represented by prosecuting attorney Timothy J. Rukowski. This matter has come before the court for resentencing. A hearing had been previously held relative to the previous sentencing of this matter. And as a result of the hearing, a new sentencing has been ordered, as well as an updated or a new pre-sentence investigation report. Ms. Bickerstaff, have you and your client had the opportunity to review the report?
Yes, Your Honor.
Any additions, deletions, corrections, or objections to the report?
Your Honor, the credit days will be off because he's obviously served quite a bit since then. But I assume we'll take care of that when you're done with the resentencing.
Let's address it right now.
I believe you would have 372 for credit days, so 145 needs to be changed. The sentence date also needs changed down to be 145.
Does 372 sound about accurate?
Yes, it does, Judge.
Okay, great. Any objection? Mr. Rukowski?
No objection, Your Honor.
Okay, thank you. Anything else relative to?
No, Judge.
Any objections of the guidelines?
No, Judge.
Do you agree with all that, sir?
Yes, Your Honor.
Thank you. Mr. Rukowski, any objection to the report as well as guidelines?
No, Your Honor.
Thank you. Ms. Bickerstaff, what would you like to say on behalf of your client before the court imposes sentence?
Thank you, Judge. He was operating while intoxicated with 2 kids in the car, and I certainly don't mean to minimize that. But his girlfriend was in the car with him too, and she's here along with her child. Those 2 children had gotten in a fight, autistic children, at the home prior, and he needed to go home because they were actually physically fighting.
They called the boy's mother. The boy's mother was unable to come and get him. And the car was a stick shift. So Mr. Thomas was the only one really who could take care of that situation. He drove almost 20 minutes when the boys started fighting in the back of the car again. And he turned around and yelled at them. And that caused a call to his mother and saying that Mr. Thomas was dangerously driving along the road. He was met by a police officer along the way. There was no accident. There was no swerving. There was nobody indicating that he was a dangerous driver. And like I said, Ms. Hicks is here today. When originally sentenced, the parties, the prosecutor and the defense had agreed to TRC. And Your Honor seemed to be inclined to sentence him to that. You said at the prior sentencing, I would send him to TRC in a heartbeat, but I have to follow the law here. That's why the sentence is MDOC. And the law didn't actually say that he had to go to MDOC. So now his new guidelines are 12 to 36 months. And because it's a resentencing, I would ask you to consider the mitigating factors that weren't submitted previously, as well as his behavior since he's been in MDOC, which could be considered by this court. Judge, when speaking of the offender, I've had a lot of resentencings, and no one is really more deserving of a mitigation to his sentence than Mr. Thomas. He's had a very difficult life. Born to a heroin-addicted mother, never knew his father, devastated when his mother basically abandoned them to foster care. The first foster home he was in, he was sexually assaulted. Another where he ended up for quite some time, the mother was a schizophrenic addict and she OD'd. So very troubled history, obviously, which led to the drugs or the alcohol in order to cope with his unprocessed trauma. Just prior to this incident, his wife of 7 years was lost to another tragedy. She was given a Percocet by a supposed friend, and it was actually pressed fentanyl, and she died. So this doesn't excuse his behavior, Your Honor. Obviously, it's a very serious offense and something that needs to be considered, but I ask that you consider Corey and his life as well. Currently, he's completed ASAB, which is, the Advanced Substance Abuse Training within MDOC, receiving excellent and good remarks. He's had 3 jobs since he's been there. His most recent job, he's actually outside the prison gates working in their distribution center for the prison. The 2 that he's received remarks on were both excellent, including one where he got a 39 out of 39 for his job status there. And I would ask Your Honor to consider a sentence at the bottom of the guidelines based on these factors.
Does your client wish to address the court?
I believe he does.
Sir, what would you like to say?
Good morning, Your Honor.
Good morning.
First of all, I'd just like to take a second to thank everybody for their time and consideration at this moment. I guess one of the most important things that I'd like the court to know is that I do have general remorse for the fear and the danger that I put other people at, and I take full responsibility for that. Taking full responsibility for that to me means doing something about it, and that's what I've done with my time. Since I left here, like Ms. Bickerstaff said, I've had 3 jobs, 2 of which I work outside the prison gates. I've attended AA on a consistent basis each week. I poured my heart and soul into completion of the Advanced Substance Abuse Treatment Program. And I provide the final report for Your Honor to review for the courts to have. As well as the number 1 thing that I've done is not only worked on but customized a relapse prevention plan, which I didn't have prior to this. It consists of 6 things which can make the difficulties in life and the choices that come at me somewhat simple. And those 6 things I've practiced and used every day. That's taking a moment to stop and think, being deliberate about people, places, and things, making sure that my reactions and my thoughts are objective, asking for help whenever I can, using substitutes, such as a quiet time every day, going outside, working out, and really just staying focused, coaching myself. when hard times come, speaking to myself about what I need to be doing. Today I stand in front of you again with my head held high, saying that I've been sober for over a year, clean and sober. And I'm proud of that. I know now today that addiction is part of who I am. But just like an individual that has diabetes, I can manage my addiction if I do these things. But you know, my addiction is not my sobriety is not a destination, it's a journey. For the rest of my life, I have to practice these things. And if I do that, then I can continue to be successful. One of the number one things I hear about every day in prison is what people are going to do when they go home, and what they're going to have, and what their future is going to look like. When I think about going home, you know, as she mentioned to Your Honor, my wife passed away about 5 months before I relapsed and caught this DUI. So going home will never be the same for me. But I have the most precious thing she ever gave me, and that's my daughter. And my daughter has my grandkids, and they're still behind me. When I think about my future, one of the things my dad used to say to me all the time comes to mind. He would say, if you want to do something well, then find others that are good at that and hang around them. So the number one thing I plan on doing whenever I serve my time and fulfill the sentence of this court is reconnecting with my brothers and sisters in the recovery community, Peer 360, going to AA, making sure that I get a job and continue to work and provide for my daughter and grandkids. You know, as far as having people behind me and having them that structure to build on the foundation that I've already made in that relapse prevention plan, and there's no doubt in my mind that I can be a productive part of society and move forward, because I've already used that foundation to stay clean and sober and ticket free in one of the hardest places on earth, Your Honor, and that's prison. I thank you for letting me speak, and I welcome any questions you might have.
Thank you. Your prior prison sentences, were you offered the same programs?
No, sir. I did take the ASAP program before, but I did not take time to customize and really build on the relapse prevention plan. And that's one of the things that the supervisor, Mr. Graham, spoke about. He really took some time to do one-on-ones with me. And, you know, I asked, one of my biggest questions was, what's going to be different? And he was like, well, you have to practice these things every day. And that's, you know, I realized that it's this time in this county jail and the time that I spent in prison that gave me back to my daughter, and not only me back to my daughter, but back to my grandkids and them back to me. But I have to practice these things. Without those things, my addiction's over in the corner doing push-ups, just waiting on me. It's part of who I am. So I have to continuously do these things. Even when the rain lets up and things get better, I can't be like, oh, I've made it. I've never made it. I have to constantly practice those 6 principles.
4 total occupants in the car, correct?
Yes, Your Honor.
The other adult was whom?
Jamie Hicks.
Why didn't she drive?
The car that her father recently had passed away, and the car that was left to her by her mother was a manual, and she hadn't quite learned to drive the manual yet. It's something that we were supposed to work on together. When I drink, I make poor decisions, and she didn't see me physically drinking that day. And so when she asked me to drive, if I hadn't been drinking, I would have been like, that's not a good idea. I understand that we need to resolve the situation with the children, but I can't drive. It's not, and you can't drive that car. So we have to figure something else out.
Well, why didn't you think about that before you got behind the wheel?
I'm an addict. I make poor decisions when I get alcohol in my system.
Consuming alcohol is different. If you make the choice to consume alcohol, that's one thing. I understand the addiction there. Understand substance use disorder. But how does that translate in saying, you know what? I'm going to go pick up 2 children and have another adult in the car with a blood alcohol level of 0.224. how do you say that that's addiction to get behind the wheel?
I'm not blaming it on addiction. Like I said, I take full responsibility, Your Honor. Had I been in my right mind, I may have been able to take, like I said, one of those steps is stop and think. Take a moment to stop and think. But instead, I was like, oh yeah, I'll help, I'll do it, give me the keys, I'll drive. Poor decision, no excuse whatsoever. Poor decision, my fault, 100%.
Appreciate that. Thank you, sir. Mr. Rakowski, on behalf of the people.
Your Honor, we ask you to take into account my statements from the previous sentencing. The court already pointed out the blood alcohol was 0.22. And as far as the reason for the stop, I mean, child called his mother saying he was scared about the driving. But other than that, we ask you fashion a fair and just sentence, Your Honor.
Thank you. All right, a couple of things to clear up first. When the court made the statement about this the second time, court misspoke, and I admit to that. I was confused because I was thinking of the two children in the car. That's why the two came up. Also, you've had 2 prior prison sentences for the same behavior, not involving a child in the vehicle, but operating while intoxicated third. Also, the court made the statement brought up by Ms. Bickerstedt about following the law. And I should have said, follow the precedents of this court, the precedent of this court. And the law allowed for a probationary sentence. There's no question about that. The law considers as well the sobriety court program. But one thing to consider, a few things to consider. The history of the defendant with drinking and driving is significant. 1997, operating while intoxicated, discharged from probation without improvement. 2003, operating while intoxicated, completed probation. 2008, operating while physically impaired, placed on probation. 2009, operating while intoxicated, third. There was a violation of probation based upon new felony behavior. To wit, another drinking and driving conviction in 2011, operating while intoxicated, third offense. There he was given jail and probation. 2017, operating while intoxicated, third offense, prison, parole violation. 2021, operating while intoxicated, third, while on parole. There he was given a 20-month to 5-year sentence, discharged on January 22nd of last year. The new charge is approximately 4 months. So the new charge that you are here before this court. So 4 prior felony OWIs, 13 prior jail terms, 2 prior prison sentences, violated parole previously. The offense occurred approximately 4 months after the beginning of parole. Drove reckless according to the information provided in the pre-sentence report, with 2 minor occupants in the vehicle and the child calling expressing fear. The court has to also consider the defendant's history, which the court has had ample opportunity to hear. We're hearing from an individual who has an associate's degree that has college debt, actually, still owing. And so a very intelligent individual, only 45 years of age. Clearly, substance use disorder is the issue. And the question is, well, why can't he be placed in the TRSC program as an example? And the court did consider that, and the court still considers it, but you have to consider the history. In 2009, he completed residential treatment. In 2011, he went back, but left without permission. And he was referred to substance use treatment, but never completed it. So maybe just a little over 3 months of treatment, but the services were offered to the defendant, and the defendant took whatever advantage he wanted of the programs or didn't take advantage of the programs. But it shows the court that you have been given opportunities to prove you can be a productive member of society, but we are having repeat behavior. And I go back to the point where, and you stated just a few moments ago, that the person that was seated next to you didn't know you were drinking earlier in the day and a stick shift. That may make sense, but you had a blood alcohol of 0.224, almost 3 times the legal limit, where a special needs child calls her own mother expressing fear of being inside that vehicle. And to the court, drinking and driving, repeated, maybe drug treatment or substance use disorder treatment, TRSC would be a good thing, or TRSC, it is TRSC. But you've been given those opportunities before. Had you been alone in the vehicle, this would be a completely different situation. But you had 2 minor children with special needs, one of which expressed significant fear because of your operating the motor vehicle. And that has to be addressed. It has to be addressed. Guideline range is 12 to 36. You are requesting the 12 months, which is understandable because at least by the 12 months, you've completed those terms with 372 days in the county jail. That would pretty much, or the time that you've been either not on bond, but in the prison system. That would make sense under the circumstances. But here, I have to look at the conscious decision you made to get behind the wheel of a vehicle with other people in the car. That's what this case boils down to. Had it been yourself, might be a different story. But you put other people's lives at stake, of which you need to be held accountable for. It will be the sense of this court that you be recommitted to the Michigan Corrections Commission, placed in the commission's custody for a period. And I'll go with the recommendation, 18 months to 10 years, credit for 372 days previously served. Crime victims assessment of $130 will be ordered. Court costs of $200 paid. It will be $200. A fine of $100, $68 in state costs will be ordered as well. Secretary of State will take appropriate license sanctions, and you're going to be out pretty soon. And it sounds like that the programs that you were completing or involved in at Department of Corrections have been helpful. Let's hope they're so helpful that I never see you in this building or any circuit court again. Because next time it could be a life that you're dealing with. And you don't want that. There's no punishment that a court could give or sentence a court could give that'll bring back the life of a minor child or anyone that's subject to your hands of operating a motor vehicle blitzed. No more. There's no reason to drive. You consume alcohol, consume to your heart's content, but throw the keys away. Don't get behind the wheel, especially if there are other people in the vehicle. It's my duty to inform you of the right to seek leave to appeal. If you're financially able to provide counsel of your own choice, the court will assign counsel for your public expense. Please initial the receipt and questionnaire form requesting the assignment of counsel, both of which must be executed under oath and filed with the clerk of the court within 42 days. Yes, from probation.
Are attorney fees waived in this?
I'm waiving attorney fees.
You ordered $100 in costs and $100.
It's been, yeah, that's all waived.
So this is
an
additional?
No, not additional. It's replacing.
So then, you mean like the current victims?
Crime victims, yes.
Okay.
$68 in state
Right,
costs.
yeah, okay,
Crime victims fee.
okay, all right.
Yeah.
All right, thank you.
Good luck to you, sir.
Thank you, Judge.
Off the record.
TCF Live, it's Monday morning. Happy Monday to all of you. I hope you're having a good day, and thank you for spending a little bit of it with us. We are now entering hour 4. Let's go back to Judge O'Donnell in Ohio. See what's going on there.
Mr. Geigerich,
Thank you, Your Honor. Before you today on State versus Clarence Bird, file 25 CR 1175. We're here today for a change of plea. It's anticipated by the state of Ohio that the defendant withdraws previously entered pleas of not guilty and enter pleas of guilty to counts 1 and 2. And in exchange, the state of Ohio will ask this court to dismiss the remaining counts at sentencing. Other than what's been spread upon the record, no threats or promises were made to this defendant to induce this plea. Thank you.
You said 1 and 2?
Yeah. Or am I wrong?
You're right.
I'm right. Yeah.
Okay. Tomazik?
That is all accurate, Your Honor.
All right. Mr. Bird, how old are you?
35.
How far did you go through school?
11th grade.
Are you a U.S. citizen?
Yes, sir.
Are you able to read, write, and understand the English language?
Yes, sir.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
No, sir.
Have you ever been diagnosed with or treated for any mental illness?
No, sir.
Did you get a copy of this indictment?
Yes, sir.
It's been represented to me you're going to plead guilty to count 1, trafficking in cocaine, a felony 5, and count 2, trafficking in cocaine, a felony 3. And then the rest of the charges would be dismissed at sentencing. Is that your understanding?
Yes, sir.
Before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you some questions. If you don't understand the question, stop me. If you want to talk to Ms. Tomazik some more, let me know, and I'll give you more time. You understand that?
Yes, sir.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes, sir.
Are you waiving that right?
No, sir. Yes, sir.
All right. If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes, sir.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them testify. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
You have the right to testify at trial if you want to. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes, sir.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you could not afford to hire a lawyer, one would be provided at no cost to you. Do you understand that?
Yes, sir.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes, sir.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes, sir.
Do you have any questions about any of these rights?
No, sir.
Do you still want to plead guilty to these charges?
Yes, sir.
Do you understand by pleading guilty, you're fully admitting your guilt to the charges?
Yes, sir.
You understand by pleading guilty to these felonies, you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control.
Yes, sir.
In count 1, trafficking in cocaine is a felony 5. It carries a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes, sir.
In count 3, trafficking in cocaine is a felony 3. It carries a 36-month maximum prison sentence and a $10,000 maximum fine. Do you understand that?
Yes, sir.
That fine, the minimum is $5,000, the maximum is $10,000 on that count, and that fine is mandatory. Do you understand that?
Yes, sir.
There is also a presumption In count 3 or count 2, that a prison sentence should be imposed, you must overcome that presumption at the time of sentencing, or a prison sentence will be imposed. Do you understand that?
Yes, sir.
I could give you a consecutive sentence. That means one sentence after another for the separate offenses. If I did that, you face a maximum prison term of 48 months and a maximum fine of $12,500. Do you understand that?
Yes, sir.
As my understanding, there's also a voluntary forfeiture of all contraband and $3,643 in currency. Is that your understanding?
Yes, sir.
Any question about the penalties?
No, sir.
All right, you understand that your guilty plea may result in a driver's license suspension of between 6 months and 5 years.
Yes, sir.
Do you understand that your felony conviction will prevent you from owning or possessing a firearm?
Yes, sir.
Do you understand if a prison sentence is imposed in this case, you might have to serve a period of post-release control as part of this sentence for up to 2 years under the parole authority?
Yes, sir.
If you are placed on post-release control and violate any conditions, the parole authority could send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes, sir.
If that violation is a new felony, you could get an additional consecutive prison sentence for the violation. Do you understand that?
Yes, sir.
And if that were to occur, the maximum prison sentence for the violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes, sir.
Do you understand that if a prison term is imposed, you are eligible for judicial release?
Yes, sir.
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 48 months. Do you understand that?
Yes, sir.
Has anybody promised you I would be lenient on you just because you're pleading guilty today?
No, sir.
Has anybody promised you what I will sentence you to in this case?
No, sir.
Do you understand I do not have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Yes, sir.
Have you had enough time to talk to Ms. Tomasic before pleading guilty today?
Yes, sir.
Has she discussed everything about your case and answered all of your questions?
Yes, sir.
Are you satisfied with the advice she has given you?
Yes, sir.
Have you been threatened or coerced in any way to plead guilty today?
No, sir.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes, sir.
Do you have any questions at this point?
No, sir.
Mr. Geiger, if the case went to trial, what would the evidence show?
Thank you, Your Honor. The evidence would show that the defendant came to the attention of Lake County Narcotics Agency, was set up for controlled buys by a confidential informant. First buy occurred on July 15, 2025, located at 2841 Bishop Road in the city of Willoughby Hills, Lake County, Ohio, which is the McDonald's. Deal was for a 1/4 ounce of cocaine for $300, of crack cocaine for $300. That deal did in fact occur. The Narcotics or Central Lake County Crime Laboratory test positive for cocaine amount of 2.64 grams. He was again targeted on August 8, 2025. Again at 2841 Bishop Road in Willoughby Hills, Lake County, Ohio, this time for a 1/2 ounce for of cocaine for $600. That deal did in fact occur. The defendant was arrested immediately following that buy, where they recovered $3,643 from his person. $600 of it was buy money, a phone that was used for the deals, and a baggie of crack in his lap sock, which was positive, sent to the Lake County Crime Lab also, along with the buy narcotics. The buy narcotics tested positive for cocaine amount of 13.75 grams, and the cocaine in his sock was 4.34 grams. I mentioned that because it's all subject to forfeiture. And the defendant was arrested immediately following. Thank you.
Thank you. Ms. Thomas, is there anything to add to those facts?
Nothing on the facts, Your Honor.
Mr. Byrd, did you hear what Mr. Geiger said, that the facts would show if the case went to a trial?
Yes, sir.
And are those facts true?
Yes, sir.
What is your plea to count 1, trafficking in cocaine, a felony 5?
Guilty.
What is your plea to count 2, trafficking in cocaine, a felony 3?
Guilty.
Ms. Thomas?
Your Honor, for the record, I did review the written plea of guilty with Mr. Byrd before coming in the courtroom, and he's prepared to sign. Date there, sign there. Today's May 4th. Your Honor, for the record, Mr. Byrd and myself signed the written plea of guilty.
May I have Devin?
All right, Mr. Byrd, is this your signature on this written plea of guilty?
Yes, sir.
Did you sign it voluntarily?
Yes, sir.
Do you want me to accept your written plea of guilty?
Yes, sir.
Accept the written plea of guilty. Defendant who was present with counsel advised of all of his rights from a knowing, intelligent, voluntary waiver. He understands the nature of the charge, the consequence of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, and voluntary. I will accept the plea of guilty and find him guilty. Count 1, trafficking in cocaine, a felony 5. Count 2, trafficking in cocaine, a felony 3. I'll refer this for a pre-sentence report. Sentencing will be June 10 at 9 a.m. Anything else, Mr. Geigerich?
Nothing, Your Honor, thanks.
Ms. Tomaszek?
Nothing further, Your Honor. Thank you.
All right.
Alrighty, friends, we're in hour 4 now of TCF Live. Just a programming note. We're going to tack on an additional 20 or so minutes today because in about an hour, I can make a phone call and find out if Mrs. TCF has to report this afternoon for jury duty or not. She did not make the morning group, but she is on call for the afternoon. So I'm going to stay live until I find that out because that's going to determine whether or not we can do In the Blind with Mike and Dan tonight. Because if she gets called in, we're not going to be able to do it. So I will stay live until I know that answer so I know what to tell you guys. Let's go to Texas. Judge Stevens.
Yeah, this shows she pleaded guilty on February 23rd. I don't have February 23rd, 2026 here on my screen to refer to.
Just we may have already processed the plea papers.
Also a little confusing, Judge, because she had two different sets of cases that are unrelated to each other with two different lawyers. So that may be creating some chaos as well.
Okay.
But
There is another case. We have two murder cases here.
Yes, Judge.
On different dates.
Yes, Judge. And we're
okay. I don't have on 41222. I've got nothing here.
That's what the 1245 is for.
1245 goes to that, Judge. She's admitting to committing that one, but she pled to the other one.
Is this you?
Yep. Yes, Judge.
Okay, I didn't. I can't understand. Thank you.
If I had a cool name like John B. Stevens, I would write it all out.
But you said there was another lawyer involved.
There's
There was a sexual assault of a child that she also pled to. It's already been
You don't need
sentenced.
any other lawyers
No,
to be here
no,
this hearing.
she's already been sentenced on that one.
You're handling both of these
That's correct, Judge.
independently
Correct.
indicted murder cases
Yes,
on this lady.
Correct.
What is our master plan?
We're asking you to follow the agreement.
Which is a cap of 40 years.
Correct. There's a fun stuff in the pre-sentence report, but it's okay. I think she covered it in the second memorandum. That we were having trouble with her accepting responsibility, but she did, I think, in the second memorandum.
In each of this states though that 41222 will be dismissed.
Yes, but you're considering the 1245 allows you to consider the punishment for it.
Okay.
But
I just
yes, sir.
wanted to make sure.
Yes,
that
sir.
There's not going to be, there will be dispositions, but one guilty disposition, one dismissal
Correct,
disposition.
correct.
Call two cases, 22-40354 and 22-41222. The state of Texas versus Lace Christian. That is you?
Yes, sir. Yes.
Present with Mr. Gertz, your attorney, and the state's attorney. Earlier, you pleaded guilty in cause number 22-40354 to the first degree felony of murder, which alleges that you shot the complainant with a deadly weapon, namely a firearm, killing the defendant, the complainant, and that this is a first degree felony. And a pre-sentence report had been prepared. Have the parties had an opportunity to review it? Are there any corrections or changes to it? State of Texas?
Not from the state, yes.
And defense?
No, Judge.
Then it's made a part of this hearing for all purposes. Now, the agreement is whatever sentence shall not exceed a cap of 40 years imprisonment. So we are looking at no less than 5 nor more than 40 years confinement in prison.
Yes, Judge.
And is deferred or unadjudicated probation even on the an option?
No, because of the nature of the offense, Judge.
And regular probation is certainly not as well.
Correct.
So it is a flat time issue.
Yes, Judge.
And one other case, 22-41222, that will be dismissed as part of this agreement, but the court can consider the facts under that case in making its decision of the sentencing in this cause number 40354, and 41222 is an indictment handed up for the first degree felony of murder. Okay. State of Texas may open and close. Go ahead.
Judge, of course, we're asking for the 40 years. There's 2 homicides that she has admitted to. One that she pled guilty to, one she's admitted to in the 1245 that she also committed that one. So with 2 murders, it's easy to say 40 years is kind of light, but due to the circumstances of everything we looked at and talked about, and the fact that she's kind of accepting responsibility. I'm going to get into that. The problem I have with this whole thing is when she first did the pre-sentence report, she tried to go away from not taking responsibility. She didn't want to take responsibility for this homicide. Then she cleared it up. And when she clears it up, then she comes back and tries to blame it on her friend who has never met this man. She says that this man, Russell Rito, pulled his penis out and tried to get her to do things. And so they ended up shooting him, killing him. But when this man was found, he was sitting in a easy chair with his hands folded, fully clothed, not looking like he had even moved, and was shot while he was actually sleeping on the easy chair. And unless she took the time to try to dress him back up and do all the things to cover up what had happened, which doesn't make sense if that's the reason why she's saying she killed him. She also lied to the police whenever the police started talking to her about whether she had gone back over there again. We have surveillance video and also her GPS showing she went back over to the house again with her friend to go take a cell phone back and to check on things. The next day, she says she went and tried to check on her grandfather, acting like she didn't do anything, knocking on the door. She said she knocked on the door to see if he was there, and he wasn't there, or didn't answer, so she went to the neighbors. But when you watch the videos, she gets out of her car and never goes to the door to knock because she knows he's dead. She goes and talks to the neighbors, acting like she never knew anything had happened. When you look at everything this woman has done, in every one of these offenses, she has lied to every moment. She has done everything. The only thing she's telling the truth about in this court today is going to be that she actually shot him and killed him. That's it. And I don't care about the motive. I don't care about anything else. She's admitting to doing it. And so we're asking for the 40 years. And she also admitted on Lonnie Scott, who was an Uber driver, that she had a one-time sexual encounter with. And then she's admitted to actually killing him also. So we'd ask for the 40 years. I don't think there's anything less you can give her.
Judge, we want to just follow the agreement at this point. Candidly, Judge, my client has struggled she's had a lot of difficulty in her life and has trouble trusting people. And I think that has yielded a number of times in dealing with the police and the probation department where she has not been forthcoming in a way that she has been with me. But what I can tell the court is she has now in the sexual assault cases and now in these cases is here accepting responsibility, and we want the court to follow the agreement, please.
All right. Did you want to say anything, ma'am? No. Okay. So I want to just be clear on a criminal history. We've got this previous aggravated sexual assault of a child conviction, correct?
Yes, Judge.
And this was a sentence that occurred just recently?
Correct, Your Honor.
Where she received 12 years imprisonment, and this was an offense that had dated back to 2014, correct?
Yes,
that's correct, Judge.
The court has reviewed the pre-sentence report and a recent memorandum supplementing this report submitted by the Jefferson County Probation Office. That was performed at the request of the defense, which asked for a supplemental due to statements that she had made during the interview. And then there is what happened the day of the offense. And I'm going to ask from probation, is probation officer here? That is.
The author's not here, Your Honor.
Okay. All right. Y'all have read it.
Yeah.
And there was some concern about the defendant pleading guilty and then in her explanations of her version of the events, seemingly not admitting responsibility for this.
Yes, Judge.
So that was from the original pre-sentence report. So we supplemented this with a follow-up.
Yes, Judge.
And then in this report, the way I read this, I'm still confused. It seems like she continues not to accept responsibility. That someone else is the one responsible. Can that be explained for the record? Because she's pleaded guilty under oath.
She has.
And I think we made it clear and methodical, but it's as though she's pleading guilty but I'm really not as guilty as you might think.
But as the court knows, when you have these types of offenses, one of the things is that people get charged even as parties, and they don't have to be specifically said as a party or anything else. I'm not saying that's what's happening here, but I am saying that had we gone to trial, she is well aware that she was present, she participated actively, and I think she's having candidly sort of a mental block about really saying I'm the one that pulled the trigger. But the reality is, Judge, that she is accepting responsibility through her plea and in recognition that she would be convicted as a party at worst, even if those events are somehow how she described. So
is all of that true, what he's saying?
Yes.
You understand? What I understand Mr. Gertz is stating, and in the legal way he does things, which is a good way and an appropriate way. You have pleaded, the fact of the matter, you have pleaded guilty. And I ask you, when you pleaded guilty under oath to murder, are you pleading guilty voluntarily and because you are guilty? You said yes. And do you understand that someone can be guilty of murder by willingly participating in the act of the murder.
Yes, Your Honor.
And you admit that you at least did that.
Yes, Your Honor.
And you did that voluntarily, knowingly,
Yes.
and accept responsibility for being part, if not completely responsible, at least being part of the responsibility as a party to the offense, as the law states, parties to an offense are culpable or can be held responsible under law.
Yes, Your Honor.
All right. Anything else to add by anyone?
And Judge, part of that,
Yes.
it's just, there's shame and embarrassment and things like that when you do something that you shouldn't have done and you know you shouldn't have done. And so I think that's just one of the challenges that people have as a natural human reaction here. But again, we're asking the court to just follow the agreement and accept her acceptance in the form that it comes, and asking the court to follow the agreement.
Anything else? Anybody? If nothing further, then Lace Christian, I'm going to find you have pleaded guilty to this first-degree felony of murder voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1, admitted at your plea hearing, to find you guilty beyond a reasonable doubt. And your culpability has been supported as well by the findings from this hearing that you admit to being a party to this offense voluntarily, knowingly, intelligently, and being responsible as a party to this offense, which resulted in the murder, homicide of a human being. You took an active role in that to make that occur. Correct.
Yes, Your Honor.
I now find you guilty beyond a reasonable doubt of this first-degree felony of murder. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 40 years. The judgment shall reflect that a deadly weapon, namely a firearm, was used in the commission of this offensive murder. Anything else to add?
Judge, I do have family members from the 1245 that would like to make a statement as an allocation.
Okay. And we're talking about section 12.45 of the Texas Penal Code, which allows
in the jury box, or do you want over here?
She can be right there. That's fine.
You want to come sit at council table with me?
Yeah.
Okay.
We're section 12.45 allows evidence of other bad acts or crimes can be considered in the disposition of a case if proven beyond a reasonable doubt, which the court finds in this case that the defendant voluntarily, knowingly, and intelligently either committed murders individually or as a party to this offense under law, makes her culpable as either a principal or a party to this first-degree felony of murder. All right, go ahead. And please introduce yourself so the court reporter can know.
Good morning, my name is Sarita Rice. I'm the sister of Lonnie Dean Scott. I'm sorry, I'm nervous.
And for the records, the sister of
The victim of the 1245 judge.
Okay.
I'm the sister of Lonnie Dean
We
Scott.
have two victims here in
And
these.
the cousin of Russell Rito.
Okay, so you're related to both
Yes,
victims then, a cousin to Mr. Rito, for which the defendant was sentenced here, and then you are a sister
Of Lonnie Dean Scott.
in the other, this is 4122, which was the other murder
Yes.
that the defendant was held accountable for. Go ahead, please.
I promised myself I wouldn't get up here and cry. These type of things you can never prepare for. I don't want to be up here alone. Being here is torture enough. You were my first. I don't know you, but you were my first. And when I say you were my first, you are the first time that I ever in my life, I'll be 53 years old on the 14th of this month. You were the first time ever in my life that I had to bury anybody. My mother had 6 kids and adopted 2. That's a total of 8 kids. All of us are grown. My mom had all her kids until you took my brother. I don't know what you told these people, how you felt about my brother, but I'm gonna tell you who my brother was. He was not a victim of recidivism. I looked up his file. Last time my brother was in trouble was in 2008 for a marijuana case, less than 2 grams of marijuana. He liked to smoke his weed. But let me tell you who my brother was. My brother had been to prison 3 times for drugs, not selling drugs, for being on drugs. He had a problem. If he never raped nobody and he never killed nobody. When my brother got out, he got his act together. He started attending classes. He was a foreman. He got certificates. He even became a business owner of his own transportation business. I had all the paperwork packed up to go. But when I went to pick up my sister up, I left it there. And I believe everything happens for a reason. But my brother had his own transportation business. He was an Uber driver. He was so excited about being an Uber driver. He would get up at 3 o'clock in the morning and drive to Houston Intercontinental Airport just so he could, that was his favorite place to go because that's where he made the most money. To go pick up people and bring them to their job to back here to pull up into the port. He was the taxpaying citizen. He went from going to prison 3 times to changing his life completely. You know what else he did? He became a homeowner that my family is benefiting from. Yeah. He became a homeowner. Legally the right way. He went to work every day. And he saved up his money and he bought a home. Something he never did in his life. He was proud of his life and we were proud of him. He was a family man. He was. We would all get together, do karaoke. He would sing, he would dance. He was not the Lonnie Dean Scott that went to prison 3 times years ago. He was a new, revised citizen Lonnie that all he did was just worked, went home, you know, did what he liked to do, but he never bought. Just like Russell trusted you. And you took advantage of that. You took advantage of him trusting you. He was a single man. You knew he was an Uber driver. You knew he had cash money. I don't know what your motive was, but you knew exactly what you was doing. You did it. You did it, and you need to take responsibility for what you did. You killed Lonnie in cold blood, and you killed Russell in cold blood. You are a serial killer. A person that kills a person 2 or more times within a cooling period. Only God knows if that was the only 2. But we're going to speak about what's facts. You killed my brother in cold blood. You wasn't fighting for your life. He didn't try to rape you. You and him wasn't in there fighting. You had to do none of that. Because you know how I know? I seen how you came into his house. My brother was asleep on his recliner. I started to wear the tennis shoes because you know what else we had to do? I had to do, thank you for my first again. I had to go clean up his house. I sure did. The blood that seeped through his couch on his floor, I had to see that. I had to get that up. The blood matter that was on that pillow that you used, that you put on his head, it shot through that pillow. So nobody wouldn't hear, I had to get that up. I had to clean this whole house up. You did that, and you need to take accountability for what you did. You are who you are. You're not gonna change, in my opinion. You are a menace to society. You have hurt and ruined so many families. You have hurt and ruined so many families. My mom is 76 years old. She never lost a kid in her life. Until you decide to take up on yourself and murder. You didn't just stop with 90. You went to Russ and whoever else. And you know what? You didn't stop on your own. You got stopped. You got stopped. So you can sit up here and tell these people whatever you want to tell them. But I know, and everybody else know, because Culotta smiles. You stopped because you got caught. Killing 90 was enough for you. You went on to Russell, and whatever happened between that, don't nobody know. Only God knows. But you are who you are. You've hurt my family. My family is still hurting. I've been on depression pills. I've had loss of sleep. I've had to bury my brother. Me, the baby girl. I have a son. No parent wants to bury their son, their child, whether it's a son or daughter. Should I have to have that responsibility? No. But my mom came to me and she said, Sarika, you're gonna have to do it. I can't do it. At that time, I had surgery. I had a femur broken on my left leg where I have a rod in my left femur right now. I had to throw my crutches to the side because I was on crutches at that time. I had to throw my crutches to the side with 32 staples and do what needed to be done. I couldn't say no to my mom. I had to do what needed to be done. You did that. That's something I would never forget. I can't get the vision out of my head what I saw in that pill, what I saw when I went in that house. After the crime scene, people came and told us we can go in. I don't know what his wife saw. I'm pretty sure the same thing his side of his family saw. But you know what I know that people didn't see? Your family didn't see what we had to see. So your family can still call you, come visit you, talk to you, write you. You can still go to the day room and laugh and play dominoes or play cards and make soups, make sprays. I know how they work. I did 10 years at TDCJS in Florida. So I know how they work. I don't hate you. I hate what you've done. I don't think that you're good for society at all. I think if you get out, and when you get out, you're gonna do the same thing. Because you didn't stop, you got stopped. You didn't feel bad about what you did. You didn't have any self-convictions and say, let me turn myself in because what I did was wrong. You didn't. You didn't call after you shot my brother. You didn't say, oh, I feel so bad. Let me call the ambulance. You didn't do anything. When I got my brother tennis shoes that he had on, they were still warm. They were still warm. But it wasn't long before, after you did what you did, that we was there. I have those tennis shoes at my house now, and a couple of his suits and clothes, because that's all I have in memory of him in pictures. Russell, I met Russell 2 years before you murdered him. I didn't even know that. Yeah, your grandpa, that's my cousin. That's my first cousin. He was a good guy. I believe in second chances or whatever. He was a good guy. When I was on them crutches and had them 32 staples in my leg and couldn't walk, was non-weight bearing for 3 months. Russell came, checked on me, brought me food. Yeah, on like clockwork. He took care of me. Diane couldn't be here today. No, you know her. I see how you looked at me when I said her name. She couldn't be here today. But she did write a statement, give it to the parole people. I hope they read it. But you've run my family. I think you deserve the max. I don't think there's no hope for you. Because you don't have any remorse. Of course, when people come to court, they're supposed to say what they have to say. But like I said, you were my first. I will never forget you. I had to go buy a hat. I went and bought my brother a tie, a shirt, a suit, underclothes, all that stuff I had to do. I didn't want to do that. I never buried nobody in my life. I was forced. I didn't want to have to do that. And to see it didn't have to put my own personal health at risk because I'm supposed to be non-weight bearing to go do the things that needed to be done when you bury somebody, death certificate, going to the funeral home, coming to Ken down here to I think his name is Ken Paxton that's on the paperwork because my brother didn't have life insurance to get help with his funeral. Yeah, I think you should have to pay that $600 to $800 back. Yep. All that. I never had done that before. Get a death certificate, had to sign it. I had to do everything. Stuff that I didn't want to do, stuff that I never knew nothing about. Because of you. So, as far as I feel about you, like I said, I don't hate you. I hate what you did. You took away a son, a father, a family member. Lion didn't deserve that. He did. If Lion was a bad guy and was around, doing awful things, I wouldn't even be here. And God in heaven, no, I'm telling the truth. I wouldn't be here. I wouldn't back that up. But I knew my brother. And I knew the man that he was. He was a godly man. He was going to church. He was getting up and working every day. Like a citizen. Paying tax. He didn't deserve it. My family didn't deserve it. I didn't deserve it. So what I have to say to you is that do your time like you did the crimes. You killed those people. You had no remorse when you did it. Honestly, I wish you wouldn't went to trial. Because I know when you go to trial, they play all the phone recordings and everything. And like I say, Culotta smiled. So all the phone calls you was making while you was in here and all that, I wish you wouldn't went to trial. I really wish. But we're here now. But yeah. I hope when you're in prison, I hope you do all your time day for day. I hope you stay healthy while you're in them. I hope you get up every morning and I hope the people that you murdered hunt you. I hope you can't sleep like I couldn't. I've been to my doctor so many times. Never been on depression pills. I had to put cameras around my whole house was full of cameras. Every corner, the middle, the side. I have so many cameras now because of you. I didn't live that way. And I'm a God-fearing person. Because of you, you had me living in fear. Every time somebody would pass by and a camera would go off, even if it's a car, I'm looking out the window. You did that to me. You hurt me, you hurt my family, and you need to pay for what you did. Just like you did the crime, you need to do the time. And I still pray for you. Believe it or not, I pray for you. I pray that God heals your heart. I pray that God, whatever this sickness is that you have, I don't know if it's a sickness or if it's a desire, if it's something that you like to do, if it's something you get off on. I don't know what it is. I don't think it's a sickness. I think it's something you get off on. But I just pray and ask God that God really help you because you need it and you're going to need it. And these people up in here, everybody have a job to do. And everybody's doing their job. But there's only one God. He got a job to do too. And one thing about him, we can ask for forgiveness and he can forgive us. But we still have to be punished for what we done. and you need to be punished. You need to stay punished. You don't never need to get out. No family should ever have to come in here and do this. Ever. Ever. I don't know how long I'm gonna be messed up behind my brother. I miss my brother. I do. I miss him. And every time he comes to my mind, I always say, not now. Not now, Lonnie, because I don't want to cry. I just want to push it away. When I'm going to sleep, you know, you think of everything hits you when you lay down. And here come Lonnie. I'm like, not now, Lonnie, I gotta sleep. So, I just pray God have mercy on you. I hope you get the max. You deserve the max. And you don't need to be out where you can harm nobody else. Children, women, dogs, cats, singing, walking, and talking. Go through your time. Because we doing ours.
Hi, everybody doing? My name is Nikita Myers. I'm Reginald's cousin, and I'm Lonnie Scott's sister. The third to the oldest daughter that my mom have. And like my sister said, when my brother died and they brought him out in the black bag, we was all standing outside. The day after that, me and my sister go to the house. We clean blood off the walls. We clean blood off the floors. We clean this house, everything. I mean, it was gross. It's something I don't want nobody to witness. It's something I don't want nobody to go through. Like I said, it's my brother. I love him with all my heart. A lot of my family, I don't know if they taking it to well. I'm still grieving because I feel like it's not true. That it ain't happening. That he's still here some kind of way. But I know he's not. And I don't know you. I don't know what you're going through. But I'm pretty sure if you had somebody that did the same thing to my brother and my cousin, they did to your family member, you'll feel the same way we feel. You need help. You really need help. And I don't know nobody that's gonna sit up in this courtroom and take up for you and take your side when you kill two people. Then when you kill one man, you went back to go to the house after you killed him and then turn around and kill another man. That's cruel and unusual punishment. And you need to be punished. You need to be punished. You need to pay for whatever you did. And like I said, I don't know you from Adam. This is my first time seeing your face. I took off work just so I can look at you in your face and tell you whatever they give you, they need to give you. And I'm here because I want justice for my brother because he can't do it for himself because he's not here. That's why I'm here. I want justice for Lonnie Dean Scott. I want justice for Reginald, your grandpa. They need justice because you here, they not. You can leave here and go back in your cell. They here, they not here, you are. You can still live your day while they in the graveyard. We gotta go visit them in the graveyard. Whatever you guys give her, she deserves. She deserves. Don't show her no mercy if she didn't show them none. And I'm through.
And one more judge from the mother of the child who was previously under, there was a sentence. We waited until everything was sentenced before
All right.
he came to speak. So
Go ahead, please. Yes, ma'am.
I'm April Robinson, and I'm the mother of the child that she assaulted, her niece. I'm here today standing for my daughter, Lace's niece. My daughter trusted you. She sincerely loved you. And you betrayed her. You violated her in the worst way possible, ever. And as a mother, you also did it to me because you know how I am about my children. And I trusted you with my daughter. And you know how Leah feel about y'all. And you did her bad. You did her wrong. For years, you continuously assaulted my child when all she did was love you. That's the worst. You're the worst type of person. And although you did all those, like, you couldn't even take accountability for what you did. You lied. You made her family, your family, turn on her. You know what they did to her? That her own people gonna turn their back on her for you when you know what you did to her? That's the worst. It's the worst. You can't even take accountability for what you did to your own niece, who you supposed to protect and love and make sure nobody else on the outside harm her. You harm her. You doing bad to her, but you know what? Even in spite of, God is good and he sits high and he looks low. My daughter is prospering. She's intelligent. She's doing wonders. Nothing you did to her is stopping anything that God has set for her to do. She's doing everything despite of what you did to her. And I prayed and I prayed and I prayed. And I'm here because I hope you sit in prison every day of your sentence and you suffer. You look like you suffering right now. You can shake your head all you want, but I pray every day that you're in there, you sit and you suffer and you take what you did, not only to my daughter, but also to Mercer. That you sit there every day and you think about what you did and you take it off because you did that. Take accountability for what you did. And get that suffering that you put on my child, that you put on his family. And I'm gonna leave it at that because at the end of the day, God controls all of this. And I'm glad he gave you 40. That was my prayer. Thank you, Judge.
Anything else?
Okay.
In this case, then we're in recess. Thank you. Next, anything else?
Okay, friends, that was heavy. Speaking of heavy, because we've talked about it a little bit, this is footage of the fire. This was footage from yesterday, but the wildfire that we have close to the TCF bunker here. This is courtesy of 12 News here in the Phoenix area. You can see it's a significant amount of burning going on. Over 1,000 acres now. Again, not in a place that will affect us unless a whole bunch of things go wrong. But thought I would share to give you guys a little bit of a visual since we were talking about it earlier. Anywho, let's go to Judge Aquilina. So we're going to do some overtime here. Again, I need to be streaming until at least 20 after, so I can let you guys know if we're going to be able to in the blind tonight. So we will go to Judge Aquilina whilst we wait for the time when I can call and see if Miss TCF has to do jury duty.
Good morning, Your Honor.
Morning. This is docket 24635 FC, People of the State of Michigan versus Colvin, Allen, Brown. Counsel, your appearance for the record.
Morning, Your Honor. Randall Berman on behalf of the people.
And good morning, Your Honor. Stephen Milks on behalf of Mr. Brown. Mr. Brown present and staying to my right at this time.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide to be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Thank you. Put your hand down. Have you had enough time to speak with your attorney?
Yes, ma'am.
All right. And sir, today was the day of the final criminal pretrial conference. However, I understand you now have a new attorney, and also you are all waiting on the preliminary exam transcript. I don't know if that was not requested or if there was some delay with the court reporter. We're going to get to the bottom of that, but that is going to cause a delay. So what we're doing is you're going to have a final pretrial on August 26th at 11:30, where you'll have to decide if you are going to enter into a plea. If there is a plea offer, I do not know. I don't get involved in that. Or if you want to go to trial. Trial has been set for September 25th at 9 a.m. Do you understand all that?
Yes, Your Honor.
All right, now, are you currently taking medication?
Yes, I am.
And that's helping you feel okay?
It seems to be, they've adjusted it a couple of ways back and forth, but I'm doing better now, yes.
Yeah, you look a whole lot better. I've seen you a number of times and you look a whole lot better today than you have in a long time.
Thank you.
So feeling okay?
Yes, I am. I think the dosage they have me on is pretty adequate. It's definitely helping me get sleep, and it's trying being in the jail this long, so trying to be patient and working through, what I've had to work through. I think the CATS program out there has helped me tremendously. I got through the anger management class, the DBT class, and the coping skills classes, and they've all helped me definitely change some inner behaviors.
All right, well, that's good start to the conversation with all of you. So, because you have quite a file here, and I think we've tried to let you out in the past. It didn't go so well. So I just asked about that as you were in there and looking at your history here. and what the charges are. You have a habitual offender for offense, notice with a mandatory 25-year sentence, so I don't know what's gonna be offered or not offered, but if in fact that is the case, at least you're getting some of that time behind you and you're getting treated, and maybe you all can now have a meaningful understanding if you enter into a plea because you're in a better mental health state.
Yes.
So I don't know, I don't get involved in all of that, but I think this delay is justified. I don't know how you feel about it, but Mr. Mills is on top of what needs to be done, what's not done before. So I think we'll be able to move with these dates, okay?
I'm totally satisfied that he gets the time that he needs to figure out what, I definitely want him to give me the best defense possible. And I appreciate him taking that time and you giving him that time.
Yeah, well,
And I'll accept it and be okay out there.
great, because he's, they are, both councils have already identified some things they need to look at, so hopefully you'll have a meaningful, stay with us in conversation, keep taking your meds, and keep working with the jail in case those need to be adjusted. I know it can take some time, but it truly sounds like you're on the mend here. But that's gonna be a lifetime journey for you, sir. And so August 26th at 11:30, I'm going to see you. You'll at that time, that's the cutoff to make a decision of whether you want to go to trial or want to take a plea offer, if there is one, I don't know.
Yes.
And then we'll have the trial September 25th and see where everything is, all right?
Yes, ma'am.
Now, you getting everything else you need in the jail?
No, no, I'm okay.
You're okay, so you're getting everything, yes, that you need right now?
What was
You're
that?
getting everything you need right now, yes?
Yeah,
All right.
I'm seeing a therapist like from the CATS program, either bi-weekly or sometimes if I'm struggling a little bit more, he'll do it weekly.
All right, we'll just keep letting them know, community mental health is good with doing that, cats and all that, so, and they also have a social worker through, the public attorney's office, so she's probably involved too as well, so that's good. On behalf of the people, is there anything you want to add to what I've said?
Not really, Your Honor. I just, as I stated, I had subpoenas out for later this month. I would note that the last trial we had was December 17th to 25. And it does indicate in my file that there seemed to be a bit of a breakdown between counsel and the defendant. I wasn't at that hearing. And I do know that Mr. Mills is relatively new to the file, so I will do my best to let everyone know not to show up for the trial that I sent out subpoenas for, and we'll await the new dates. Thank you.
Counsel?
Nothing further. Thank you, Your Honor.
All right, thank you, good luck to you.
Okie dokie, friends. Let's go over to Judge Boyd, a new contestant over there.
Hello. Good morning. How are you doing?
I'm better.
I'm sorry, Odyssey is running so slow. I'm waiting for it to upload your case. All right, so we're here today for sentencing.
Correct.
All right, the court is calling 2022 CR 7545 State versus Alejandro Almazan. Can I have parties announced?
Brandon Prada for the state.
Ted Wood representing Ms. Almazan.
All right, and are you Miss Almazan?
Yes, ma'am.
All right, you had entered a plea of true to violation of condition number 1. And number 15 was waived without objection. And we're here today for sentencing. Okay. All right, anything you want to say on behalf of your client?
Judge, Ms. Almazan's grandfather, sure, I'd like to bring him up to offer testimony. May I bring
Yes.
him up?
All right, they're going to have you step back over here, okay?
Yes, I'm with
Yes, ma'am.
your back to the counter.
Hello, hello. Would you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Richard Gooden.
All right, you may proceed.
Thank you, Judge. Richard, how exactly are you related to Alex?
I'm her grandfather.
And how long have you known her?
Her
Her
whole
entire life,
I
okay.
was there the day she was born, so.
Okay.
yeah.
What is the nature of y'all's contact now at this time? Does she live with y'all?
Yes,
Okay. And does she have any children?
yes.
How many? And where do those children live?
with us right now.
Okay. Are you and your wife taking care of the children?
Yes.
Okay. Has this situation with Alex put a strain on y'all's resources and your time resources regarding taking care of these kiddos?
Yes.
Okay. What else is going on right now in your family life that has brought you here today?
Well, my wife is gonna need surgery again. Repair something that she had done in 2020 and then redone in 2021. So it's, her health is not the best right now.
Is it fair to say that she's over 39?
Yes.
Okay. You have a statement that you
Yes.
would like to get you prepared, that you'd like to read to Judge Boyd.
Yes.
Why don't you go ahead and read?
All right, well, before you read that,
Yes, ma'am.
let me just tell you, because I always like for people to be on track. These are my issues, right? She's on probation for DWI third. She's pled true to another DWI.
Yes.
Now, a lot of what I do, one, depends on if I continue her, obviously she needs inpatient treatment because outpatient treatment isn't doing it. Then the other thing is what is happening with that new number one. Does anybody know?
Well, she pled true to it.
Yes, I mean, she pled true to it, but what is the state's plans for that new number one? Is the plan we are going to continue with that? Is the plan, we're going to dismiss that and see what happens in this case? I mean, you all probably need to discuss that because otherwise she's going to be in limbo. Because even if I were to continue her and continue on probation and say she's going to inpatient treatment, she can't leave to go anywhere. No place will accept her if she has this case pending. So what I would suggest humbly is that you all talk about that new number one to see specifically what's going to happen with that. And then, because that needs to be taken care of. Because even if I were to refer her to felony drug court, they won't accept her if she has this pending case.
I humbly take your suggestion.
All right. Okay. Thank you. Thank you.
Thank you.
All right. On Tucker,
It's us.
A Man in His Dreams. I think I'm the only person who remembers that.
Lindsay, thank you for the $10. That's hilarious. Beth's jury duty standby fees. Thank you so much.
Is on. Got it. All right. So what is the update on Mr. Tucker?
Your Honor, when I spoke with Mr. Tucker this morning and my staff, the only thing that we are waiting on, which is relatively easy, is just a letter of interest, and then we're going to schedule him for an assessment. If we get all those things done, like we talked about this morning right now, we can have them done by the end of the month.
Okay. Then what we'll do is we'll recall you for the end of the month.
Sound good?
All right. So everything should be in with them. Okay.
I'm getting done as soon as possible.
All right. When you say the end of the month, what do you mean though? I probably shouldn't have said end of the month.
ask that, Judge, what do you mean by the end of the month? The 28th is the last Thursday, Your Honor. That's the day that we do blue folders. So as long as he has everything in within the next 2.5-ish weeks, we'll count it 3 weeks. 29th, I should have an answer.
All right. So what we'll do then is we'll set it for the week of June 8th. And you need to have everything.
It'll be done before that.
All right. Thank you. Ms. Ferguson, I need a recall for the week of June 8th. Oh, June 8th. All right, June 8th. All right, thank you. Thank you so much for coming down. Do y'all have an update for me?
Yes, Judge. We haven't,
Oh, he's discussing. Okay.
we're just gonna be running concurrently with whatever you decide.
Okay. Who's next?
William, take one down.
Melania Williams. Hello, hi, morning. So today is plea deadline?
Yes,
day?
Your Honor, today's our plea deadline date. We would have to request some additional time, Your Honor. We recently got a new offer.
Okay.
So I need some additional time for Ms. Williams to consider the offer and work on some mitigation and hopefully get this worked out in the next 30 days.
All right. How old are you? 17? All right, Norma, set this for mid-June. This is the final pre-deadline date.
Yes, Your Honor. Understood. Thank you.
I can do,
That'll work good.
All right, thank you.
Thank you, Judge.
You're welcome. Who's next?
it's, Ruby de la Cruz, it's 2, 1 down.
Dela Cruz? Okay, I still don't have the email.
Okay, I'll send it over.
All right, thank you.
Judge, on Ms. De La Cruz, we're set for discovery. I just conferred with the state and it looks like we're still missing a couple of items. I gave them a USB. And then she has 2 cases pending.
Mhm.
And on the other case, it does also look like I'm missing a surveillance.
Okay. All right, Norma, give me a reset date. This is your final discovery date, 45 days.
Thank you.
You're welcome. All right, once you sign the reset form, you'll be excused. Okay.
Oh, I didn't know what you were handing me. Thank you.
You're welcome.
All right, friends, let's stay in Texas, but let's go back over to Judge West. It's been a couple hours since we've been there now.
Even this defendant's recent.
Hang on just a second. Good morning, you're Carly Davis. Could everyone please hold it down? So Ms. Davis, you were late for court. I forfeited those bonds. I'll recall those forfeitures. It is extremely important that you are on time to court. Do you understand? And so your cases are set for trial to begin with jury selection next week. Is everyone ready?
Your Honor, I think that my client has something she'd like to request of you.
Judge, before we get to that, given this defendant's recent violations of the drug patch, I'd ask that she be drug tested today.
So the drug patch, I have prescription. We've been
Okay.
going, yeah, that we've been doing that. We got the prescription. It's the same one. There's nothing different. Otherwise, I would absolutely agree with you. So you're not driving, correct? Right. So that was part of that agreement. And so what do you have to say?
With all due respect, I have, after our last time in front of you, I had signed a plea rejection. And it was recently she had told me the offer right before we came in here that morning. And you asked if I had signed a plea rejection on the tablet. She stated no, so we went in the hallway and signed it. That plea rejection was different than the one that she had offered me right as we were at the elevator. So I was a little confused and it didn't click until we were already, it was over. I was still here waiting for my Uber and I sent her a text and I never heard anything back. And I've tried to call several times. She finally had texted me about a month later and said she had been out. She would call me the next day. And I can show records of where I've been trying to get a hold of her and.
So what
Your
do you-
Honor, I just have my phone records.
Well,
that
yeah, it could have
went
been
through.
30 days. I mean, there's not all that adds up because it's only been 30 days since your last court date. Here's the thing. I just need to know if we're going to trial or not. Do you want to, if you want to take a plea offer, then you guys can discuss that this morning and we can get it taken care of. But your case is set for trial next week. I'm not changing attorneys. I'm not setting it for anything. I will order the cases for trial tomorrow after my jail docket. And so you will know then what the trial order is for next week, but after today, there won't be any plea agreements accepted. Do you understand that? So do y'all want to visit for a minute or do you want to go forward with trial?
Probably.
Visit for a minute? Okay, I'll hold it. Y'all go visit.
Thank you.
Yeah, thank you, ma'am.
Beyond this for Anderson, we did rejections.
Okay.
Yeah, I didn't want you to
Tori Anderson.
Your Honor, for the record, she told me her name is Tori Sam, and that was the name on her driver's license. She got pulled over. I don't know how they got Tori Anderson. That is her maiden name, but
Okay.
Tori Sam is her name.
Ms. Malfino, I guess if the state wants to maybe look into that and.
I will,
add that.
and I'll make
Okay,
an amendment if necessary down the line.
all right, ma'am. So Tori Anderson is your maiden name. So that is you, correct?
Yes, ma'am.
Okay, and so Ms. Anderson, in cause number 25 DCCR 1165, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle. That's from July 31st of 2025. And what that means, ma'am, is that if you go to trial and you're found guilty by a jury, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand?
Yes,
Answer out
ma'am.
loud. Thank you. And I have here on the tablet a plea bargain rejection that has your signature on it with Mr. Parker's. That shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, to reduce that
To evading.
to a misdemeanor evading with a 1 year deferred probation. Is that your understanding of the offer?
That I rejected it?
Yes, ma'am.
Yes, ma'am. I'm not guilty.
Okay. So then what I'll do, is there a video? Have y'all had an opportunity to
There's a
review?
video, and I've talked to Ms. Mufino about it, and it's pretty consistent with what she's told me, and
Okay, that's fine. I just want to make sure. So, Ms. Anderson, I'll get your case set for trial. And Ms. Anderson, Mr. Parker has been appointed to represent you at this point. He's one of the attorneys who handles a lot of cases for me as a court-appointed lawyer. With your permission, I can release him and appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you? It's up to you. You can keep Mr. Parker or you can get another attorney.
I'll keep what I have. I'm not interested in changing.
Sure. All right, Mr. Parker, we'll begin preparation for trial. Make sure you stay in touch with Mr. Parker so that you'll know when to be back and ready for trial, okay?
Yes, ma'am.
I'm sorry to interrupt.
Go ahead.
If I may, and this is no way directed at Mr. Parker. He has discussed this case multiple times with me. We have exchanged notes. I have watched the video and taken notes myself on it and relayed some information. I agree that some parts of it are consistent, but I would just ask, again, not directed at Mr. Parker, but at Ms. Anderson, that she watch it before we get to jury selection.
Okay, thank you. And Mr. Parker, if you, Ms. Anderson, make sure you make an appointment, go visit with Mr. Parker so you can watch the entire video, visit about everything. If there's any change before that trial date, let me know ahead of time, because once you get to the trial date, I don't accept plea agreements. So y'all visit before then, don't wait till the last minute, okay?
Yes, ma'am.
Thank you. You're free to go.
Thank you.
Okie dokie, friends, let's go back to Judge Boyd, and you guys can ride with her for a few minutes while I make that phone call.
Mr. Diaz has been evaluated twice
Mhm.
by two different psychologists, one in Bear County, and one in Kerrville for Medina County.
Mhm.
Both of them have determined that he's incompetent to stand trial. And we are waiting for his competency to be regained so he can stand trial here and also stand trial in Medina County.
All right, so this needs to be referred to the magistrate's court. Has it been referred to the magistrate's court?
Yes, ma'am, we just came from the magistrate's court. She's the one who,
Oh,
yeah.
okay, because I'm like, he shouldn't be up here then.
well, I agree. I don't know
No.
why they
Yeah, I have
put
no
it on
idea.
the docket, but
All right,
they are.
so when are you set, next setting in, magistrate's court?
We are not, Judge.
Okay,
To my knowledge, the only setting I've had since magistrate court is with you.
okay.
Judge, if I may,
Yeah.
I believe that when he's found incompetent, I came from the magistrate's court. When he's found incompetent, he needs to be restored to competency.
No,
before
I
he can-
understand that. My thing is, usually there's a date, because when somebody's found incompetent, you can't just put somebody in limbo. They have to have hearings. And I believe it's 120 days in some instances, in some days it's 90.
Should go
So
down and
there
check.
should be a setting. No, I mean, that's fine. What I'm gonna do, Norma, recall this in 120 days.
Thank you, Judge.
All right, September 1st.
Perfect, Judge.
All right, and if for some reason competency is not restored by that time, just let us know beforehand.
I will.
For some reason, Odyssey is down, so I can't see anything.
Oh,
All
no problem.
right, thank you.
Thank you.
All right, who's next? All right, Cruz Tovar. What page is he on?
Okay, 5%.
All right, are you okay? All right. Court is calling 2026 CR 003-571, State versus Cruz Tovar. Can I have parties announced?
Megan Galloway for the state.
Roberto Vargas for the defendant, ready to proceed, Your Honor.
And are you Mr. Tovar? Counsel, you received all discovery. Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Tovar, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Tovar, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Tovar, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand? Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 6 months in the Bexar County Jail under 1244 and an $800 fine. Did you understand that to be your plea? Defense?
Yes, Your Honor.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, any such motions?
No, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest? State any evidence?
State offer states 1 in attachments.
No objection, Your Honor.
All right, state, you may be excused. Did you review the waiver and consent to stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. We expect that the court will accept the agreement that we have with the state.
All right, this home, where you were, is that your mother's home? Okay. All right, this is what the court is going to do. Court is going to find you guilty, sentence you to 8 months in the Bexar County Jail under 1244. There's an $800 fine, time and money to run concurrent. There's to be no contact with Maria Cristina Ramirez without her consent. There's to be no residing residence. And the court will give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. You're going to have to make better decisions, understand? And when you are released from custody, make sure you get that checked out, because sometimes there's damages behind that, all right?
Say something?
Sure.
What's that?
Mhm.
I'm actually in Reds because I was denied the proper treatment.
Mhm.
I went to the hospital, to
Mhm.
get X-rays. You did MRIs, CAT scans. Whatever they found in those results of those X-rays and scans, wanted to give me liquid morphine and Teradol.
Mhm.
So, as you said, they didn't tell me what was wrong, but I know that something had to be wrong for them to give me what they gave me.
Okay.
But that being said, the hospital told me to let this unit know when I started feeling the same symptoms that got me to the hospital in the first place. Yesterday, I tried to do that, and I'm in Reds. And I just wanted to let that be known that I'm not getting the proper care that I need. And that's only because they don't want to. And it's not because I'm being disrespectful. You can look up I've never been written up for any disciplinary hearing, nothing like that. I'm respectful to all these guards.
Mhm.
And I'm in Reds because I needed help.
Okay. So this is what I'm going to tell you. The time that you've been sentenced, if you're in general population, usually the deputies, the sheriff's offices will give you 2 for 1. So every day you serve, you'll get credit for 2. Normally, when you're in red, it's day for day time. But what I can tell you, I'm not over how much time they give you outside of the day for day time, okay? But when you're released, you'll need to check that out. And of course, you can file whatever thing you want to file. If you want a civil attorney, you can take care of that on that end, okay? All right, good luck to you. Thank you.
Maybe excuse you, Honor?
Yes.
Thank you.
Okie dokie, friends. That will do it for today. If you didn't see in the chat, Beth, her group has been released from jury duty. So we can have In the Blind tonight. And we will. 7 p.m. Eastern, 4 p.m. Pacific. So join us over there. I don't have it scheduled yet, though. I did not schedule it because I don't know what was going to happen. So shortly, I'll have that scheduled over at In the Blind. And we'll be good to go there. And we'll be back here, obviously, tomorrow morning, 9 a.m. Eastern, 6 a.m. Pacific. And next week, we'll bring back the pre-show. So we'll have that going, too. Hope you all enjoyed yourselves. I know there were some heavier cases today, but I thought it was good court. So I appreciate all of you joining. Over 500 moved in and out today. Yeah, about 550 people. So good day. I'll see you all this evening, hopefully. Join us over there. And if not, we'll see you all in the morning. Take care. God bless.